Okay, let's start with the plea and arraignment calendar, see who is here and what we're doing with that. And then I think we have a plea with Ms. Craig. Is Ms. Craig here? Yes. She is, okay. And is Mr. Bastian here? He is, fantastic. I'm going to be seeing a lot of you. You have graciously picked up, I don't know how graciously you did it, but I appreciate you taking them, a bunch of the former Eric Johnson conflict defender cases. So we'll get to that soon. So position one is Bobby Bradley. Mr. Bradley. Okay. Hello, Ms. Willingham.
Hi, Judge. And I see that Mr. Bradley does not appear to be present. Subject to notice, the state would ask for a bench warrant.
Okay. Ms. Nelson, we're deep into May, so Mr. Bradley would have received notice of this calendar.
Yes, it's a notice calendar, Judge.
Okay. All right. He bonded out about a month ago, and Ms. Rockwell represents him on an unindicted case, and he was supposed to get a lawyer in this one. So we'll see. He may still walk in. He's only 6 minutes late right now, but if he doesn't show up, then we'll do bench warrant for Mr. Bradley. How about Richard Creamer? All right, Mr. Jordan, any reason why Mr. Creamer wouldn't be here?
No, Your Honor, it looks like this was transferred from non-complex, but the state would ask for a bench warrant.
Okay. It's an older case. I'm trying to figure out why it just got here. Stuff had been happening this year in non-complex. And then it's supposedly a complicated non-complex case, a theft by taking. Okay, well, it's here, but Mr. Creamer isn't, so we'll do a bench warrant. How about Caesar Pavon? He should be in custody.
Yes, I spoke with him with an interpreter at the jail last week and filed a waiver, so we're happy to bring him out if the court wants to, if we have an interpreter here. But
no, I mean, we do have Mr. Lars here. If you want to just let Mr., is it pronounced Pavon?
Pavone.
Pavone. If you want to rely on Mr. Lars just to let Mr. Pavone know, didn't really need to bring you over, but waived and all is well enough. We'll get discovery flowing your way. Is this a Mr. Shapiro case?
It is. Good morning, Judge.
Good morning. So you'll get discovery to Ms. Feely. Well, we'll do a scheduling order. That'll start all the different clocks running. You'll get discovery to Ms. Feely. There'll be a motions deadline, et cetera. Okay. Do you want to speak with Mr. Pavone?
I prepared him for this was probably what was going to happen, but sure, I'll speak with him since we have the interpreter here especially.
All right. When we're taking Ms. Craig's plea, which is fast approaching, maybe they could just for 2 seconds talk to Mr. Pavone.
Your Honor, 2 quick announcements on Ms. Craig. Attorney Bastian and I are still finalizing the last minute details. If after the reading of this calendar or the calling of this calendar, if I can step outside.
Sure.
And finalize it.
I'm not trying to rush it. I thought it was ready, but it's almost ready.
Almost ready, Your Honor. And also on Mr. Creamer, the CP that was mentioned in the on the calendar has now been indicted under 23 SC 187626, and I believe that's an aggravated assault.
For Mr. I didn't hear anything about a CP and Mr. Creamer. There was for Mr. Bradley.
There was originally on the calendar, Your Honor, I believe, or I may have written in these notes myself. I do apologize.
All right, so Mr. Creamer has a new case,
Yes, sir.
which will conveniently come to us because of this old non-complex case. And that case number again?
23 SC 187626.
Judge McBurney,
Yes, ma'am.
just to shed some light on that case, this is actually a transfer from Orca to us, so just wanted to throw that out there.
The 20 SC case?
Yes, Judge.
Okay, well, that would make sense then why it was rattling around in non-complex. It would have been on Orca's docket. And then we have this brand new, it's just 2 weeks old, aggravated assault indictment that is currently assigned to Judge Whitaker, but I bet her case manager is going to figure that out real quick. Okay, but Mr. He bonded out on, oh, that was from 2020 as well, the aggravated assault. All right, well, he's out there somewhere. Thank you. Marcus Ware. Ms. Wood, is it your case?
Yes, Judge, he's mine. I have talked to him several times. He knows what's happening today. If we could just bring him out, I will be filing a waiver of arraignment today.
Hold on one second. Yes? Oh, okay, great. Well, let's do Mr. Ware. So can we just bring him to the door? Do you need him to sit down with Ms. Feely? What do you prefer?
If he could just come to the door, that's fine, Judge.
Okay. Hey, Mr. Ware, I'm Judge McBurney. How you doing? Good. Ms. Wood, your lawyer, is on one of these screens. I don't know if you can see her, but she let me know that she's been talking with you about your case. And my question for her was whether you were waiving arraignment. In other words, she's going to enter a plea of not guilty for you. And then we'll get the process started of the prosecutor, gentleman seated there with the glasses. He'll get discovery to your lawyer so she can meet with you, share with you whatever evidence the state has, doesn't have. And then you and Ms. Wood will figure out how to move forward. Does that make sense? Ms. Wood, anything you want to share with Mr. Ware in earshot?
No, Your Honor, I do have discovery. ADA Jordan and I have already begun discussions on this case.
Okay, so you'll file a waiver of arraignment and we'll take care of the scheduling order.
Thank you, Judge.
Okay, any questions, Mr. Ware? No, sir. Okay, thanks for coming by. So Mr. Ware has a co-defendant, and that's Joshua Bostic. Is Mr. Bostic here?
I spoke with him just to get updated contact information. He did pre-indictment have a conflict attorney, which obviously he still needs.
Yes, I saw that. Whenever I see Travis Foreman's name, I know one, it's an old case, and two, we need help.
So we have already contacted Mr. Haddad in our office to see where we are with that, and I'll pass this
Okay, so Mr. Bostic, you're a co-defendant with Mr. Ware, gentleman. That was loud. All right, Ms. Woodall is on mute now. So you're a co-defendant with Mr. Ware. You need a lawyer. You've got a right to a lawyer, so you don't have to find one. We'll get one for you. Way back when, you had a lawyer named Mr. Foreman. You may not even remember that, but he briefly represented you. Then you bonded out, and it's taken a while for the state to indict this case. So what we're going to work on now is lining up that lawyer for you. So you and that lawyer can have a conversation and we'll figure out how best to move forward. Okay. Any questions? All right. Let me make sure we've got good address information for you. You got something in the mail telling you to be here? Okay. So I've got a Hank Aaron Drive address. Is that right? Not an apartment number, just a street address? Okay. That's how you'll get stuff in the mail. Hold on one sec. All right, I need you to take a seat and I'll get back with you in a sec. All right, Mr. Creamer, you came in. How you doing? All right, Ms. Feely, you're representing Mr. Creamer?
So I did speak with him briefly. I need to just qualify him real quick.
Okay.
But otherwise, I believe so. It'll be me or Ms. Wood.
Okay, well, if you don't mind qualifying him, Mr. Creamer, you now have 2 indicted cases in Fulton County. The one that's on today's calendar is old. It's a 2020 indictment for theft by taking. You have a new indictment that was just indicted a couple weeks ago that's been assigned to another judge, but it's going to come here because newer cases go to older cases. You were indicted for aggravated assault. There's actually also an old allegation, also from 2020. We're going to need to make sure we've got good address information for you. Ms. Feely is going to talk to you about your finances as to whether you qualify for appointed counsel, if you're going to need to hire an attorney. So I'm going to ask you to sit tight until you and Ms. Feely speak, and then we'll figure out what we're going to do next. Okay? Thanks. All right. I think we covered everything on the plea and arraignment calendar. Mr. Bastian and Mr. Jordan, why don't you two talk about Ms. Craig? I need to.
This is Attorney Rosenblum. I'm on the 9:30 calendar for plea and arraignment for Colby Elder for status.
I believe he's on a 1 o'clock calendar.
I received 2 different calendars. That's why I'm here.
Okay, let me look. We've got a final plea calendar in the afternoon, and Colby Elder, and you are on that. You're position 3.
All right. He was, according to the email I got from Ms. Nelson, the calendars was on for this morning too. So that's why I'm here. I just want to make sure.
Okay. Well, I appreciate you being here. Just to be doubly safe, are you able to join us at 1?
I can definitely do that. Just to give the court an update, he did not show up to our office to rehire us.
I didn't know he was supposed to rehire you.
Yeah, that's why we're back on the calendar per the notes. He apparently advised the court that that he wanted to try and work it out with us. He was supposed to show up yesterday and never showed up.
Didn't do that. Okay. Well, let's see if he shows up at 1. And if he does, we'll figure out what his plan is. I'm sorry to make you show up twice, but if you don't mind patching back in at 1, that would be great.
Thank
All right. Thank you. All right. The only other thing I have for this morning, we got to figure out what to do with Mr. Waller. That's the revocation. And then Lonzie Johnson. Is Mr. Johnson or Ms. Johnson here? Nope. That was to see if Lonzie, I guess it's a Mr. Johnson, had completed all of the pretrial intervention. Ms. Wood, have you had any contact with him?
I have not, Judge, and just for a refresher, the virtual PTI was just to get Lonzie into the PAD program. And I remember we had an issue when PAD went to pick him up from Rice Street and a DeKalb County hold popped up. And so unfortunately that messed up his release. I checked last week. I don't believe he's still in DeKalb County Jail, but I've been unable to contact him.
Okay. Yep, I see that. So in July of last year, we had to release him to DeKalb, and then he probably didn't connect with the program after that. So, Mr. Jordan, what do you want to do with this case? Do you want to reactivate it? It is on judicial hold because in theory, Mr. Johnson was going to participate in that program. He hasn't. Who knows where he is right now?
Your Honor, at this juncture, the state would move to reactivate the case.
Okay. All right. All right. So as I understand it, Ms. Feely, you're going to talk to Mr. Creamer. I need to talk to Deputy Gordon and Ms. Nelson real briefly, and then I can probably let Mr. Bostic go. We'll take Ms. Craig's plea if that's what's going to happen, and then we can do the Waller revocation. Anyone else here for a case they thought was going to be going on this morning?
Yes, Your Honor, Donald Young has a bond hearing this morning.
Okay.
He had a consent bond, but we heard that you would like more information.
I would. I read the consent bond and just need to better understand how a $5,000 bond makes sense. Need to know how the child is and where the child is and how Mr. Young won't be within many miles of the child while the charge is out there. So we'll do that. Let me sort out the Mr. Bostic situation while other folks are talking, and then we can do that. I don't know that Mr. Young was brought over.
He was.
He was. Perfect. Then we'll have that discussion. He can come out for that.
Okay, great.
Okay.
Thank you.
All right. Anything else? All right. I will be right back. Did Mr. Lares talk? Ms. Feely, did he leave? Did you get to talk to Mr. Pavon?
Oh, I have not.
Yeah, get on Zoom.
Okay, to get on a Zoom. Just poke your head in the jury room and see when he can get back there with you. I just don't know if this is the show. This is whatever you. And if it's something like that, I just said it's, I showed up for work. I don't know what's in the system.
Yeah, he didn't want to leave. Plus the just travel costs. He lost. Yeah, so he's not, when I had talked to him, he was talking on his meeting. Security. And then another issue is just for people that like they live in custody come in and try to pay bonds in the state. It's a lot harder to do a bond in the state. It's 80% they would if you lived in the state. And so that's why it's like, I'm not sure what the cost would be to the family. It's already not insurance. I talked to mom briefly about it. She's trying to figure out how to do it.
Okay.
And I would also do the project.
Okay, all right.
And we do to be able to issue the project. She's a copy. So I'm
I just sent you an email. I printed this out as well and gave it to Deputy Gordon. I'm gonna reach out to Ms. Jackson right now on the call. Oh, did she say anything?
Yeah.
Okay.
So I know you.
We're still waiting on it.
I'm checking on it. Good morning.
Morning, excellent. Thank you. I was about to send you something in the chat. So if you just check on that, Deputy Gordon is as well. Thank you.
Okay.
Right, but I mean, we're our position, so they weren't on. They weren't on. Injuries, according to what the son did, it's on the fights and stuff like that. So all of it is just.
Yeah.
Distributed, right? I did see photos. Yeah. Put away kids on the zone. Think about it. Because I've seen all that.
For the.
Like just kids getting violent and stuff. That reason people all the time like that. So I'm just, there's more going on.
I got you.
And also, I know you know about the whole, just. There's a lot of information.
Yeah.
Yeah. Had observed inappropriate behavior, and that's what started to break down. She didn't observe sexual, you know, it was more like you get a feeling that about you something makes you uncomfortable.
So he's
Right.
this.
So.
But it's.
I'm gonna be.
Okay, so pretrial's looking into it right now as well. And we'll just figure out what we need to do.
He did not tell me. He did it because he just wanted to. That's how. I don't know. If she left on me, I would not reply.
I know she's not bad.
She may be right outside, but if you don't, you have to go or?
Well, Rich Carnesville looks before a plea and the other interpreter didn't show up. And we have 5 other judges waiting, so.
So I'll just get it right quick.
Yeah, just see if we, because it'll take 2 seconds. So let's just see if we can find Miss Feely.
That's what I call Rich Carnesville.
And this should be a lot more than that, based on just the warrant I've read alone. Yeah. But it's, yeah, so I mean, and just for. And I know it's not you, but just like, you zoom out, you see like, he took it to the hospital, he manipulated, he spoke to that time, he was upset, but he.
I need to talk to her.
I understand this under, honestly, it's very common.
And I know what you said about
But I was like, I need to talk to him before we do anything. Well, because the son, I have a letter from showing to the police and rights and either. And that was what comes with.
Yeah.
So I'm not convinced all those people are, I'm not showing that he did not recognize him.
Okay.
Just
I mean,
for the record, I
my
know.
thought was that my thought was.
No, absolutely not. That's not, and you talk about, oh, I talked to his mom, I talked to his son, that is not a what happened. He, as soon as he heard about it, he was like, we need to test it. That was his first one. Mom figured out there was actually something like that actually happened. That was.
What's it? Having people look at it.
It was, I think, she's trusted.
Sure.
Just being separate. Donald was afraid to make it.
Yeah, I know.
Donald
I've
was
talked to Grace
afraid.
about that.
There's no history of factual, I understand. This is not a situation when this is all grown. He has 3 other kids who also don't have facts, but my understanding, the mother isn't with those children.
Okay.
So, this is his oldest one. I think it was just, he just was overwhelmed. I think a lot of it just happened because he just heard about it when that happened. I'm sure. I think he just, I'm just, he says he doesn't apologize. But again, I don't think that necessarily deserves the max here, you know what I mean? Like,
No.
I think it was a reaction, not knowing how to process it.
We need to resolve.
Can I have Mr. Young's case number?
Yes, Judge.
It's 22 SC 185-516.
Thank you. Thank you, Mr. Lares. Thank, Ms. Feely, I know you don't represent Mr. Bostic. I need to chat with him a little bit, if you don't mind being by his side for that. Mr. Bostic, if you don't mind coming up to council table. And Mr. Shapiro, if you don't mind being the ADA on this one, because I think it's Mr. Jordan's case. So, Mr. Bostic, there's a warrant that pretrial services swore out because way back when, in November of 2021, it's alleged that you weren't keeping up with your curfew. tell me what you understand the conditions of your bond to be. It's not quiz. I've got it in front of me, but I'm wondering, you got your bond almost 3 years ago. Are you still wearing an ankle monitor?
No, sir.
When did that come off?
Probably like a couple months ago.
How did it come off?
Working, it snatched off my leg.
Meaning it's not that a judge said it was okay to take the ankle monitor off.
No, sir.
What kind of work were you doing?
It was like in construction of a temp service.
Okay. And what happened?
I was working and something had got caught onto my leg and then snatched it off.
Okay. What did you do with it?
It's at home.
Okay. But the strap is broken now.
Yeah, and like little attachment part that go to the strap.
Okay. Had you been charging it?
No, sir.
Okay. Are you still working?
Not currently.
When did you last work?
Last work probably like I say a month ago.
Okay. Through a temp agency?
Yes.
All right. So, Ms. Feely and Mr. Shapiro, for some reason it printed upside down. Mr. Bostic got a bond in June of 2020. And I can't tell what judge signed it. Wasn't me. It was back when it was unindicted, so it was a magistrate who signed it. It's a $51,000 bond. He's posted that. Count one was $50,000 straight, and then count two was $1,000 signature bond through pretrial services. So Mr. Bostic was on pretrial supervision. In November of the following year, a year and a half ago, pretrial said, we want to come off the bond because of a curfew violation. No action was taken. And of course, the case wasn't indicted then. It was languishing in CP land. It was only very recently indicted. My thought is that we modify the bond, keep it at the 51,000, but get rid of the curfew and the ankle monitor requirement, but keep the two no contact provisions. There's no contact with Mr. Ware, his co-defendant, and also no contact with the alleged victim, a Mr. Neal. I don't know more about the case than you do, other than that Mr. Bostic has been on bond for almost 3 years with no arrests or anything. And it seems like those modifications are consistent with his ability to come to court 3 years after he was first arrested in this case and to more or less stay out of trouble. Do you have any issue with that, Mr. Shapiro?
Judge, I apologize if I missed this, but as to the ankle monitor, what's the issue with the ankle monitor requirement?
Well, one, it's been I don't know if Mr. Bostic was paying for it, if it was county funded, but I'm not quite sure what the point of an ankle monitor is 3 years later if the person's showing up. I've got no information that Mr. Neal, the alleged victim, is someone who's been worried that Mr. Bostic's been around him. And so I think, and the curfew, it was a 24-hour curfew except for medical emergency. That obviously prevents Mr. Bostic from working. So rather than implement this warrant now that is a year and a half old, it seems like allowing Mr. Bostic to stay out of trouble and work and deal with these serious charges. Some other judge 3 years ago decided that bond was appropriate for him. And it sounds like the violations of the bond are, one, the passage of time. I'm amazed that the ankle monitor hadn't come off already after 3 years. And then the curfew isn't practical if Mr. Bostic's going to be working. So I don't know. Why don't we do this? I'm going to cancel the warrant and ask you to ask Mr. Jordan to have your victim witness program reach out to Mr. Neal to see if they can find Mr. Neal 3 years later. And let's see how he's doing, because he may have a view on this and there may have been reasons why. Maybe it's not a stranger on stranger situation. The no contact with Mr. Ware is an easy one, He's in custody. Mr. Bostic isn't, but I want to be sensitive to Mr. Neal's situation. So why don't we do that? Ms. Feely, I'm not asking you to speak a whole lot on Mr. Bostic's behalf. Your office has a conflict, but I didn't want this to be a pro se situation for Mr. Bostic. It's not his fault that he doesn't have a lawyer right now.
And I think that is exactly what I was going to say. If he had the benefit of counsel, we probably would have moved to have the ankle monitor removed by now anyway. And I don't know exactly how the pretrial services bench warrant works. It seems like a revocation of bond would require some due process. I don't know what the difference is.
Right. I don't know. And it is, of course, 1,000 of the 51,000. And I appreciate why pretrial services did what it did, and they did it in a much more timely manner than we are. It was in November of 21 when some pretrial services officer made it clear that it was difficult to keep Mr. Bostic on his curfew. But then because it was stuck in CP land, there wasn't a way to get in front of a magistrate to say, how about we modify the bond so that Mr. Bostic can work or whatever was going on. He's here now. And that's my proposal to modify the bond that way. What I may do is just spread the 50,000 that he's posted across the counts in the indictment and take out that pretrial piece because they've said that's not what they want to be in the middle of.
Judge, I just want to place on the record that our office did attempt to reach out to the victim, in this case, Mr. Neal, on April 27th. The telephone number that we have appears to be disconnected. So I will follow up with ADA Jordan to try and get up-to-date contact information. But obviously, understanding the court intends to move forward with modifying the bond, I just wanted to place on the record that we have not had the opportunity to discuss that with the victim yet.
Okay. And that's what happens when it takes 3 years to indict a case, is that's not his number anymore. Okay. I'm going to make a note to bug Mr. Jordan and probably just have a week turnaround time. And if there is input from Mr. Neal, that may shape what I do. Otherwise, number one, Mr. Bostic, we're working to get a lawyer for you. But number two, I'll modify your bond and hold on to that ankle monitor. Don't throw it away, because at some point we're going to need to get it back. And I'll also modify the curfew. Are you trying to get back to work, or you're done working, or what's your plan?
I have an interview probably like in a couple of days.
For what?
This company called Fetch. I don't really know what they do, but I know it's a warehouse.
Okay. All right. Well, we will work on getting you that lawyer. As I mentioned, that is job one, so that there is someone that can be speaking on your behalf. And we'll keep sending things to that Hank Aaron Drive address. If that changes, you need to let the court know. Okay.
Yes, sir.
All right. Thank you. Okay, so Mr. Creamer, will your office be representing him?
Yes.
All right.
I've been messaging with Ms. Wood. I believe he will be hers.
Okay. Do you want to, because Mr. Creamer's here, do you want to do the waiver of arraignment?
Yes, we'll get it filed today, and I've gotten contact information for him.
All right. Let's make sure so we can figure out if you need to do a change of address. You still on Far Road?
Right.
Apartment 356?
No, not 356,
Oh.
257.
Okay, so we'll need to do a change of address form. So Ms. Feely's going to fill out a change of address form for you and waive arraignment, and that'll get this 20 SC case going. Your 23 SC case, just numbers, like I said, is with another judge, but that's going to get sent here once they figure out you've got an older case here. And then Ms. Wood, who is Ms. Feely's law partner, but is on the screen, she's likely going to end up being your lawyer for the two cases. But if you've given good contact information to Ms. Feely, she'll pass that on, okay? So before you go, make sure Ms. Feely has written the correct address on that form. And once you see it there, you're good to go. No, Mr. Bradley. All right, so we're working on the Brittany Craig plea. We could talk about Donald Young now. Why don't we do that? If we can bring Mr. Young out, please.
Judge, Mr. Bradley was my only case on the calendar this morning. I hung around just to see if he appeared. If he does, please let me know, and otherwise I will get a bench warrant over to Ms. Nelson.
Great. No, you should do that. It's 40 minutes in, so he did not make it.
Okay, thank you, Your Honor.
Thank you.
You want to speak with me first?
Oh, no, you guys.
Should we go here or the podium? Okay. All right, we'll just go to the podium, just so we're not here. It's in Buckland. Buckland.
Great.
Let's change your address today, okay?
Okay.
Good morning, Ms. Rivers. You ready?
Good morning. Yes, I am.
Okay. We're going to go on the record in State versus Donald Young. It's 22 SC 185516. Mr. Young has been indicted for cruelty to children in the first degree. And I received yesterday a proposed consent bond that would get Mr. Young out. And I wasn't comfortable after I looked in the docket about the nature of the offense and the jail commitment order, et cetera, just signing it without understanding more about what is happening let me get the indictment up. How do you pronounce your son's first name? Seven. Seven Young's life. So, Ms. Sarfarazi, the concept of bond wasn't the issue so much as the conditions and understanding a little bit more about what's happening with Seven Young.
Sure, yeah.
Because as I was understanding it, Mr. Young was representing to the medical professionals. He had full custody of Seven. And yet the bond condition would need to be, you have no contact with Seven until we resolve this. So
No, on supervised contact.
well,
Yeah.
maybe not. That was the recommendation.
Right.
So that's why I wanted more information. I wasn't inclined to allow contact based on what I was seeing in the docket. So I figured we should have a discussion about that.
Sure, Your Honor. So just a little bit about Seven. He's actually in St. Louis with his grandmother.
Okay.
So he's there full time. Talking
As in Missouri.
yes.
Okay.
And speaking with both his grandmother, Shirley Young, and Donald, the plan is to keep Seven in Missouri until this case is resolved perfectly and Donald can get his life back in track.
How old is Seven?
He's 13 now? 15 now.
Okay.
And so we don't believe there'll be any. Donald's going to stay here. We have a good house for him in Hampton, Georgia, with his aunt. Seven is going to be in Missouri with his grandmother. So there'll be no issues of any type of violent contact or anything of that nature. We would like to have supervised contact we can do it by phone or FaceTime, so he can speak with his son. Seven wants to speak with his dad. He wants to talk to his dad. Donald's the full-time caretaker normally. So the mom is not in the picture. So he's really his only parent that's actively in his picture. And though he has his grandma and some family in Missouri, he still wants contact with his father. So that's why we asked for that supervised condition.
Okay.
And we've explained to Donald, as well as to Seven, as well as to Shirley Young, the grandmother, that they can't speak about the case. So it's just about how school is and very general things that between a father and a son, but nothing about the case.
Okay. All right. What else do you want to tell me about Mr. Young?
Yeah, so I'll give you some of the bond factors, Your Honor. So he is 36 years old. He is originally from Missouri, but he moved to Georgia in 2018. We do have a good address for him in Hampton, Georgia, with his aunt. The address he was staying at, he was evicted because he's been incarcerated this whole time. He does still have his job where he works for a package. He works at a warehouse where he does production and package work. And he still has that job. And we do have good contact information for his supervisor, who's also was willing to house him before we found out the aunt could house him.
How would Mr. Young get from Hampton to work?
Your aunt's car?
Yeah.
Your aunt's family car.
Okay, you've got a valid license?
Yes.
Okay, and your aunt would let you use her car?
Yes.
What would she do to get around?
I think she's retired.
So she'll just stay at home while you're at work?
I believe so.
Okay.
And there are other family contacts in Georgia with his cousins, and he does have some longtime friends, Your Honor. And just a little bit about this case. There's a lot more to this case than is this being charged, Your Honor.
I'm sure.
There's a lot going on with this case, and we've already begun discussions regarding how to resolve this case. Donald's wanted to resolve this case for a while, and we're asking for the $5,000 bond, Your Honor, because he can't afford anything. And if we go over $5,000, I could apply him to the bail project. I can't apply him to the bail project if we go over $5,000. And so that's why we're asking for a $5,000 bond. The family might be able to do it, but if not, we want to have a backup. He hasn't been heard on bond since first appearance back in October 10th of 2022, Your Honor. So he sat no bond for a very long time. And while he's been in the jail, he's actually shown to be a very model inmate. When he was housed, he's currently housed at Cobb right now, but when he was housed at Fulton, one of the inmates was actually getting stabbed on March 3rd, and Donald stepped in and protected that inmate, and he even got thanked by the deputy. So it wasn't a case where he was causing trouble. He saw someone in trouble, and he wanted to give aid and got himself stabbed in the process. And then also, while he's been in Cobb, he's in the honor dorm for good behavior. And so, again, Your Honor, I don't think we have any issues with him not coming back to court. He's already indicated to me he doesn't want to leave Georgia until he resolved this case. He doesn't want his son here until this case is resolved, because he wants to get his life better and back on track, because it's been derailed by all this.
Okay. Ms. Jackson, good morning. I don't know if you received this calendar. Do you have information on Mr. Young? Do I need to give you his case information?
No, Your Honor. He appears to have one prior arrest, and that was out of St. Louis, Missouri on May the 17th, 2018 for malicious possession of a weapon violation. There was no disposition for that arrest. Nothing in addition.
All right, thank you. Mr. Shapiro, this sounds reasonable. I'll tell you my one concern, and then I'm happy to hear any other concerns you have, although you seem to be consenting to this basic framework. And Ms. Sarfarazi has touched on it. It's having contact with Seven. And I appreciate Seven would be safe because he's 1,000 miles away, however far St. Louis is from here. I am leery of dad talking to son, hey, this isn't a big deal. You need to make this go away. And I appreciate Ms. Sarfarazi said they won't talk about the case. Policed by whom? Not by you, not by me. But I'm also sensitive to a 15-year-old who maybe the only parental influence in his life right now is grandma, and maybe wanting one generation closer. So I'm interested in your perspective on that.
So Judge, I certainly agree, and that was the state's chief concern as well. I'll simply note everything that Ms. Safarazzi has described as far as the circumstances of where Seven will be residing in Missouri with his grandmother. It was also our understanding that Mr. Young was going to remain here in Georgia. And so we can certainly try to alleviate that concern with more specific language in the consent order. Mr. Young has no defects history, and so no unsupervised contact. The state felt sufficiently covered the requirement, not only that he obviously have no violent contact with Seven, but also that they not discuss the particulars of the case. I have also spoken to Miss Young, who has custody of Seven in Missouri.
Ms. Young would be grandmother.
That's correct, Judge.
Okay.
And she understands that that is the state's concern, is that any discussion that they would have by phone shouldn't involve any discussion about the allegations in this case. She has described to me that any of the phone conversations would be sort of she has a central phone in the home that she can monitor their conversations. And so I certainly understand the court's concern, and it was the state's concern as well. And so to the extent that we need to include additional language, but the state's intent at least was that Mr. Young would be able to have some contact with Seven without necessarily having the ability to have in-person contact or to discuss the particulars of this case with him.
Got it. Okay. Mr. Young, do you have any questions or anything you want to add to the discussion?
I would just say, thanks for your time. This has been a difficult time for me. As first time, I don't have any, like she said, I don't have any priors or any violent history. So I'm just looking forward to trying to get my life back.
Okay. You've been in jail for a long time. All right. I will, if you could send again the proposed bond. I'm going to tweak the language a little bit. The dollar amount's not the issue. I'll maintain that so that the Bail Project can assist Mr. Young if that's what they choose to do. We'll also need that address unless the address was in there. You don't
I'll
need.
change your address today, Your Honor.
Oh, well, so two things need to happen. File a change of address, but put in the bond or the email you send me, because I will make it a condition of bond that Mr. Young resides at 123 Main Street in Hampton. I need to know what that is. So either in the email to Ms. Nelson or in the actual bond, put that address. Because one condition is going to be you reside at that address. And another will be no out of state travel for any purpose. And then another will be this no in-person contact with Seven and telephonic or FaceTime, whatever the electronic communications will be restricted, not about the case. And I'll word it more eloquently than that, but nothing that we haven't been talking about here.
Okay, thank you.
Okay. All right. That's it. Any questions?
Oh, no, thank you.
Okay.
And Judge, I'll confirm about that address, and we'll send a revised proposed order.
Great. I'll take care of that today or tomorrow.
Thank you, Your Honor.
You're welcome. All right, Mr. Jordan, you're back. Are we able to handle Ms. Craig's case?
Your Honor, if I may, I believe that the Woodall family is here. If I may step out briefly to speak with them.
Sure, you should. And there's a Ms. Woodall. There's a Linda Woodall online as well. So if folks are free to be heard if that's part of what we're doing here. But please do talk with the family. We've got a few minutes. I need to be wrapping up around 11:30-ish if we can do that. And we've got this and Mr. Waller. We can always roll Waller over. Ms. Wood, are you here this afternoon?
I can be, Judge.
Okay, we may be able to do both, but why don't you talk with the Woodalls?
Thank you, Your Honor.
Sure.
Judge, can I be excused?
Yes, sir. Thank you. I don't know if it's hit the docket yet, entered the 414 order in Mr. Porter.
I did just see that, Judge.
So I think we're done. I haven't seen any notice of appeal. The clock is ticking on that for the plea and bar. And then we are trial ready. Well, meaning there are no more motions we have to litigate. And so my hope would be we get it on a sort of summertime here, not a Judge Emerson calendar, trial calendar.
Understood, Judge.
Okay.
Thank you.
Ma'am, what case are you here for?
Wilder.
Okay. We'll try to take care of that this morning. Able to get in? She figured it out. Okay. Can we check on Mr. Jordan, see if they're ready out there?
Mr. Jordan.
Yeah, he's the prosecutor talking with the family. And is Mr. Bastian ready? They're ready to go. They're not ready? They are ready. Okay. Not till Jordan comes in. So yeah, just see if Mr. Jordan's ready.
Might be Brittany Craig.
They said another minute or so.
Okay.
Judge McBurney,
Yes, ma'am.
I just accidentally sent you a chat. It was a question for Ms. Nelson, but it can be for you too. On Richard Creamer's new case,
Yes, ma'am.
should I go ahead and do a waiver on that one, or do you prefer I wait until it's actually transferred?
Go ahead, and we can do a scheduling order. We're not playing hide the ball with Judge Whitaker's folks. It will be here, and that way, then the two cases can move in sync.
Okay, perfect. Thank you.
You're welcome.
Is there any way I can get a cancellation of that?
I just did it. I sent it to Ms. Nelson. So she's got for Bostic. Yeah, she's got it. Do you want me to print it out here? It's not file stamped, but it's got my signature.
It's a cancellation?
Yeah.
Oh, yes, please.
Okay. It says set aside. It doesn't say cancel. That'll work?
Yes.
Okay, I'll print it out right here.
Thank you for that time, Your Honor.
Happy to do it. Mr. Bastian, can we bring Ms. Craig out?
Yes, Your Honor.
Great. Is she able to stand up at the podium, or would you prefer that you all be seated at council table? I'm fine either way. Court reporter just needs people in front of a microphone.
She could sit here, but she's fine either way, Your Honor.
Okay, well, you've got your stuff there. We'll just have her sit next to you.
Okay.
And Your Honor, Ms. Craig had a second case that was transferred to Your Honor either this morning or yesterday.
Okay.
Which is a fact by shoplifting, and it will be included as a global.
And what is that case number?
That is
20, ready?
Yes.
23 SC 181 861.
861. All right. Thank you for flagging that.
actually, I had 22 SC 181.
Yes, you're right.
Okay.
I'm a year ahead.
Okay.
I'm in the current design time zone. You know about that.
All right, Ms. Rivers, are you ready?
Yes, I am.
Great. We're going to move forward with 23 SC 185695, State versus Brittany Craig. We're also resolving today 22 SC 181861. Ms. Craig is in court with her lawyer, Mr. Bastian. Mr. Jordan is representing the state. The 23 SC case is a complicated one. We have a number of family members of Mr. Woodall I'll hear about this more as you share the facts of the case. And I want to invite everyone to stay in court. If it's going to be difficult to maintain composure during the presentation of the allegations, then I'm going to ask you to step outside. But as long as folks can remain relatively peaceful, you are perfectly welcome to be in here. I know this is not easy to hear about, and it's important that you be given a chance to be here. So, Ms. Craig, in a moment, Mr. Jordan is going to put you under oath. When you're under oath, you'll need to answer his questions and mine truthfully and completely. If you have questions as we're working through this, it's important that you let Mr. Bastian or me know that. I need to be confident that you are understanding what we're talking about. And no one's trying to make it complicated, but this is a stressful time. So if at any point you're not following what's going on, will you let me or your lawyer know?
Yes, sir.
Okay. All right. Mr. Jordan, when you're ready.
Thank you. Ms. Craig, can you please raise your right hand?
Raise your right hand.
Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
You may place your hand down. Can you please state your true, correct, and legal name?
Brittany Craig.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I am 34 and I made it to 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses? In the indictment ending in 695, you have been charged with the offenses of abandonment of a dead body and concealment of death of another. And Your Honor, those will be the only two charges that the state would be asking for a plea to on that indictment.
Counts 1 and 2.
Yes, Your Honor.
So the entering auto and theft related offenses, those are all being dismissed?
Yes, Your Honor. The state's going to move to dismiss those counts.
Okay. And for Ms. Craig, that is 3, 4, that's 3 through 9. Okay.
Yes, Your Honor. And in the indictment ending in 861, that you have been charged with the offense of theft by shoplifting.
Yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
yes, sir.
Have you had enough time to speak with your lawyer, Attorney Bastian, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes,
Mr. Bastian, do you waive formal reading of the indictment?
I do.
Do you also waive any and all defects in the indictment, including any with respect to Ms. Craig's name?
I do.
Ms. Craig, do you recall having being arrested on these charges?
yes,
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Bastian, do you know of any outstanding warrants that are related to these charges?
I do not.
Ms. Craig, has your attorney advised you the minimum and maximum sentence
yes,
for each charge that you are pleading to?
yes,
And Your Honor, just for the record, for the indictment ending in 695, for count 1, abandonment of a dead body, that is a minimum of 1 year and a maximum of 3 years. And for concealment of death of another, it is a minimum of 1 year and a maximum of 10 years. For the theft by shoplifting indictment, that is a minimum of 1 year and a maximum of 5 years.
Okay.
Ms. Craig, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, in indictment 695, the state's recommendation as to count 1 is 2 years to serve. For count 2, the state's recommendation is 5 years probation to run consecutive to count 1. The special conditions of probation being that Ms. Craig have no contact with her co-defendant, Mr. Brian Arnold, whom is also listed on the indictment. She must provide truthful testimony if called to testify against Mr. Brian Arnold. And Your Honor, as I will elaborate upon after reading the facts of this case, the state would also ask for a condition of Ms. Craig's probation is that she cooperate with law enforcement in the ongoing investigation in the death of John Woodall. And Your Honor, for the felony theft by shoplifting, the state's recommendation is 2 years to serve to run concurrent with the 23 SC 185695. Ms. Craig, is that the negotiated recommendation that was communicated to you?
yes,
Do you understand that the court is not bound by that recommendation and can sentence you to the maximum on each charge and can run those consecutively or one after the other?
yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that since you are being placed on probation as part of the state's recommendation, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you a United States citizen?
Yes,
Do you understand that neither the court nor your attorney nor the district attorney's office has anything to do with parole?
yes,
Do you understand that the Department of Corrections or Board of Pardons and Paroles, no one can guarantee parole no matter what anyone has told you?
yes,
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
yes,
Do you understand your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your ability to obtain employment?
yes, sir.
Do you understand that by pleading guilty, if you use, receive, possess, or transport a firearm, or use a firearm in a commission of a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you were giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Ms. Craig, how do you plead to these charges of abandonment of a dead body and concealment of death of another and indictment number 23 SC 185695?
Guilty.
And how do you plead to the sole charge of felony theft by shoplifting and indictment number 22 SC 181861?
Guilty.
All right. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that since these are all felony charges that you're entering a plea to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And do you understand you only have 30 days from today to file a direct appeal?
Yes, sir.
And Your Honor, if we can begin with the facts for the less consequential case, which is the theft by shoplifting. On December 17th of 2020, an officer from the Atlanta Police Department was dispatched to a theft from vehicle call at America's Best Contacts and Eyeglasses. The officer made contact with an individual that advised that there are 2 female suspects who shoplifted from the store as they were trying to get away, but an officer was nearby and was able to detain them. The 2 female suspects were a Miss Rasheen, and that's Rasheen, Garvin. Garvin has normal spelling, and the defendant, Miss Brittany Craig. The officer also spoke to a witness who stated that at approximately 11:30 that day, she observed the 2 female suspects enter the store, taking 8 prescription glasses, concealed them in a tray, and ran out of the store without paying for those items. The total amount for the stolen recovered items was $1,050. The 2 suspects, including Ms. Craig, were both arrested and charged with theft by shoplifting over the value of $500.
But there's no restitution because those 8 pair were still on them and were returned.
Correct, Your Honor.
Okay.
And Your Honor, for the facts for the indictment ending in 695, on August 4th of 2021, at approximately 2:31 p.m., Atlanta police responded to 410 North Avenue, Atlanta, Georgia, in reference to a person non-responsive inside of a vehicle parked in the Dairy Queen parking lot. Upon arrival, officers observed a gray 2020 Toyota RAV4 with a white male, later identified as Mr. John Woodall, slumped, leaning forward in the front passenger seat. Due to all doors of the vehicle being locked, officers requested a tow service to make entry into the vehicle. At 12:30 that same day, APD responded to 486 Ponce de Leon Avenue in Atlanta, Georgia, in reference to a missing person call. Upon arrival, officers spoke with Miss Dawn Woodall. Dawn has normal spelling, the wife of the missing person, Mr. John Woodall. Mrs. Woodall explained to officers that the last time she saw her husband was on August 3rd of 2021 at approximately 5:30 p.m. at Grady High School while they attended a parent-teacher meeting. Mrs. Woodall further explained that at approximately 6:30 p.m. after the parent-teacher meeting, Mr. Woodall stated that he was going to drop off his daughter's laptop for repair. Mrs. Woodall then explained that Mr. Woodall texted his daughter at approximately 7:12, stating that he had just dropped off her laptop at the Fix-It repair shop in Midtown Atlanta. Mrs. Woodall explained that this was the last correspondence anyone received from Mr. Woodall and that he was driving a 2016 gray Toyota Highlander. On August 5th, the detectives met with Mrs. Woodall at her residence, and Mrs. Woodall advised detectives of several transactions on Mr. Woodall's business and personal credit cards from August 3rd of 2021 to August 4th of 2021. On August 4th of 2021, Mr. Woodall's vehicle was located on the license plate readers traveling southbound on Boulevard Northeast towards Ponce de Leon Avenue at 11:09. Mr. Woodall's vehicle was then spotted traveling northbound on Monroe Drive and Ponce de Leon Avenue at approximately 5:29 a.m. Using this time information with the license plate readers, detectives were able to locate footage from the Video Integration Center or VIC cameras on August 4th of 2021. At approximately 5:28, Mr. Woodall's vehicle pulls into a Shell gas station located at 486 Ponce de Leon. A black male approaches the vehicle and places an unknown object in the left rear passenger side of the vehicle. At approximately 5:29, Mr. Woodall's vehicle was then seen pulling into a Wendy's parking lot located at 660 Boulevard.
Maybe you're gonna tie this up, but we have a 2016 Highlander and a 2020 RAV4. Were people just mistaken about which car, or are we going to hear about cars being switched?
Your Honor, I think that we will hear about cars being switched. I've spoken to Ms. Woodall and she can definitely correct me if I'm wrong, but I think that the vehicle that they eventually found, Mr. Woodall.
Was not Mr. Woodall's car.
It's actually a rental vehicle, is that correct? Yes.
Okay.
It was a rental vehicle. So that's primarily why the state at least wanted to move forward with only counts 1 and count 2.
Got it. So just so I'm following this and I understand why it's now a particularly complicated case for the Woodalls, Mr. Woodall was originally in the Highlander. When he left Grady Midtown High School to drop the laptop off, he's in, no.
So we had the rent car because the Highlander was being fixed.
Okay, so I'm confused. It's less critical now. I thought the report to the police was that Mr. Woodall would be in the Highlander. But he wouldn't be. He would be in the RAV4, which is what he was found in.
That's
Okay. All right.
So detectives were able to see video surveillance footage from the Wendy's located at 660 Boulevard. And while reviewing the footage, Mr. Woodall's vehicle is seen pulling into the Wendy's drive-through and circles the building and parks. Detectives note that Mr. Woodall can clearly be seen slumped over and buckled in the front passenger seat. The driver of the vehicle, later identified as co-defendant Mr. Brian Arnold, is seen exiting the vehicle and walking away. A passenger from the right rear seat, later identified as Ms. Craig, is also seen exiting the vehicle. At approximately 6:34 a.m., Mr. Arnold and Ms. Craig can be seen fumbling around the interior of the vehicle, and Craig is then seen leaning over in direct contact with the body of Mr. Woodall, checking to see if the seatbelt is secured, still holding Mr. Woodall's body in place. At approximately 6:37 a.m., Craig can be seen clearly engaged in a cellular phone conversation and doesn't to attempt or render aid to Mr. Woodall. At approximately 6:38 and 6:40 respectively, Mr. Arnold and Mr. Craig can be seen walking away from Mr. Woodall's vehicle. At 6:34, Mr. Arnold and Mr. Craig and an identified male suspect are seen entering Mr. Woodall's vehicle, and then the vehicle is seen exiting the Wendy's parking lot and traveling east on North Avenue, pulling into the Dairy Queen, which was located at 410 North Avenue. On August 18th of 2021, Ms. Craig was located by Atlanta police and a field interview was conducted. Ms. Craig was read her Miranda rights and she voluntarily agreed to speak with detectives without a lawyer being present. Craig admitted that she was in the vehicle with the victim and she assumed that the victim was asleep or possibly inebriated. On August 24th of 2021, Atlanta Police Latent Print Unit confirmed and advised the fingerprints recovered from Mr. Woodall's vehicle belonged to Ms. Brittany Craig from the interior front passenger door handle, and that Mr. Arnold, that his fingerprints were also found in the vehicle. Detectives learned of several transactions where Mr. Woodall's credit card was used after it was apparent that Mr. Woodall was deceased and did not make those transactions. I have here a few transactions that were made, Your Honor. One for $204 from an Ameris Bank, another one from a North Avenue ATM for the amount of $203.25, and a public supermarket withdrawal for $602.95. On September 9th of 2021, Ms. Craig was arrested by the Atlanta Police Department Fugitive Unit and transported to the Fulton County Jail. On August 27th, Mr. Arnold was arrested. Ms. Arnold and Mr. Craig essentially both provided statements that they received the victim's vehicle from each other during their interviews. Your Honor, I know that that's a particularly complicated it's a winding factual basis. I have reached out to Ms. Woodall last week in regards to this case. This was a very sad situation and a very bizarre situation, to say the least. This was a homicide investigation that a Detective Thorpe was handling for quite some time before he retired. And if Mrs. Woodall feels comfortable with me sharing this, the autopsy did reveal that Mr. Woodall had a lethal amount of heroin in his system. And it was such a large amount that police did believe that foul play may have been involved. It's for the Woodall family, speaking for the Woodall family, and his sister will come and give a victim impact statement as soon as I'm finished with the state's presentation, that this is a situation where the Woodall family would like as much information, as much closure as they can possibly get. This was a very bizarre situation where it appears that Ms. Craig, Mr. Arnold, and the third unidentified individual were all riding around with his deceased body in the car. They would just like any information that they possibly can get for how did Mr. Woodall actually die. His death has left a hole in the family. He had, was it 2 teenage daughters? Yes.
13 and 16.
2 teenage daughters, and of course left Mrs. Dawn Woodall a widow. So they would like any information as possible, as much information as possible. That's why I believe that this is a fair negotiated resolution. For any information that Ms. Craig can provide, we believe that any information will be useful to the Woodalls getting any kind of closure that they possibly can. And at this time, Your Honor, if you would permit, Mr. Woodall's sister would like to read into the record the victim impact statement from Mrs. Dawn Woodall.
Sure. You can, if you want to be seated, you can be at council table there. If you'd rather stand, you can come up to the podium. I just need you near a microphone so our court reporter can take it down. And if you'd introduce yourself so we attribute what you're saying to the actual speaker, I appreciate it's coming from Dawn Woodall, but you are the spokesperson.
Hi, I'm Melissa Woodall Curtis. I'm Jay Woodall's sister. And I appreciate the opportunity to share our perspective with you today. This has kind of been a compilation of Dawn's feelings, my mother's feelings, and the rest of the families.
There is a Linda Woodall.
It's my mother.
Okay.
That's Jay's mom.
Got it.
And then my daughter, Catherine Curtis, Jay's niece, is also on the Zoom.
Okay.
On the evening of August 4th, 2021, we received a call that would change our lives forever. Jay Woodall, husband, father, son, brother, uncle, financial professional, community leader, was found dead in his car in a Dairy Queen parking lot. On the day before, Jay and his family had attended his daughter Bella's 9th grade parent orientation. Afterwards, he left to drop off Maddie's computer for repairs, and we never saw him again. Jay was educated at the Baylor School in Chattanooga, University of Colorado for undergrad, Georgia State MBA. He had a successful career in the insurance and financial planning industry in Atlanta for many years, working with Allstate, SunTrust Bank, and Highland Capital. He was beloved by his family, his dear friends, neighbors, colleagues, and clients. Jay never met a stranger, was always happy to lend a hand, tell a joke, share what he had with those in need, and most importantly, was a consummate family man. He was the guy who took the kids to their checkups, to run errands, take them to school and their activities, to get groceries and make dinner. He dried tears, bandaged scraped knees and broken hearts, and helped with the homework. He led his neighborhood community association and developed a safety plan as well as a neighborhood watch. He helped his clients protect their families with financial planning. How could it be that he could end up dead in his car in a parking lot? Almost 2 years later, and still none of this makes sense. Large withdrawals were taken from his bank account. His credit cards and phone were missing, and he was found dead in the passenger seat of his car. Camera footage shows that 3 individuals were driving around in his car with him in the passenger seat. Jay was a big, strong guy with no enemies. How did this happen and why? Fast forward to the present. The ripple effect of Jay's absence continues to grow. Dawn, Bella, who's 16, Maddie, 13, have suffered continuous trauma since the evening of August the 4th, 2021. I was there when the call came in. I heard my nieces scream and cry when they heard their mother sobbing uncontrollably, asking if their daddy was ever going to come home. I will never be able to forget the searing pain of that moment. A few days after Jay's memorial service, Dawn's employer let her go, and she's been searching for a job since then. Dawn has had an extremely successful 20-plus year career in the medical and pharmaceutical industry. This was a huge shock and has been disruptive to a family already in crisis. Jay is missed by our mother, myself, my husband, and our kids. Jay was the favorite uncle, the confidant, the business succession plan, the trusted family advisor, and the fallback if any of us needed anything. And the same goes for Dawn's side of the family. Jay was devoted to his in-laws, Milton and Rose, as well as his sister-in-law, Melissa. Jay was our VIP who just can't be replaced. Our society needs more men like Jay. He got things done. He gave freely of his time, talent, and treasure. He truly cared about all people and was always sensitive to the needs of others. Our mother, Linda, shares, "My son was my heart and soul. Our family is left bereft, and we will never get over the loss of our beloved Jay." Dawn, my sister-in-law, Jay's wife, shares, "The minutes, days, months, and years to follow have been full of pain, grief, and emptiness, trying to understand how this could have happened to a man that was the epitome of selflessness and love. Losing my husband and father to our beautiful girls has impacted us both emotionally and financially. I lost my partner who helped me create, shape, and nurture an environment where we were all able to thrive in being able to make a difference in the lives we touched within our communities, as well as the commitments we held to be the best versions of ourselves. We lost our protector, our beacon of light and hope when things would somehow not go our way. He bestowed many values to our girls that they will forever be thankful for, but it has left a very painful hole in our hearts and lives. I'm left to raise them alone when this was not our plan. I've taken on this important task alone, wishing he were here helping me make important decisions that will impact our lives forever. He was such an active husband and dad, making his loss profound in every way. My daughters will never be able to laugh with him and share about their days at school, receive the warm hugs he often gave them, share about their futures, listen to his guidance when asked. He will never be part of those precious moments in their lives, like cheering them on for graduations, their first job and apartment. He will not be there to experience their firsts of many significant moments in their lives. His loss will be forever felt by them. Time will help us heal, but our lives will never be the same. And for that, my heart weeps. I hope that we can have a small token of peace knowing what happened that awful night on August 3rd. None of the details leading up to his death make sense, and they certainly do not reflect Jay's behaviors. It is not okay for the individuals who were with him not to remain accountable for how the night ended in his death. In closing, how could something like this happen? The facts don't add up. What is the penalty for the losses our family has experienced? Was Jay scared, hurt, threatened, or drugged prior to his death? How did others get his car, his wallet, his phone? Why was he in the passenger seat? These thoughts are my daily nightmare. There have been so many tears and heartbreak, which unfortunately will be part of us forever. Now there is no father for two young girls to guide them through adolescence. No husband to help support and protect his family. No son to aid his mom when she needs assistance or a hug. No uncle to advise his niece and nephew on things that they don't want to discuss with anyone else. I have lost my lifelong best friend, my only sibling. Why? We have to wonder how these things might have been if they'd only dropped Jay off at the emergency room at Grady. It wasn't that far away. If he was alive when they took over his car, they could have spared his life. They chose not to do so, and now we are left with the traumatic fallout from that decision. We are all heartbroken. This could have been avoided. Our family deserves to know what happened so we can have some semblance of closure. Thank you.
Thank you, Ms. Curtis, for speaking on behalf of the family. Mr. Jordan, anything else?
Nothing further from the state, Your Honor.
All right. Ms. Jackson, what can you tell me, please, about Ms. Craig's criminal history?
Yes, Your Honor. The defendant has 8 cycles. The last arrest was June the 6th, 2021 in Fulton County for theft by shoplifting. The defendant appears to be on probation for 2 different cases that ran concurrent. One for entering an automobile. That case number is 18 SC 163438, 1 year of confinement and 4 years of probation. And there was another one for burglary. That case number is 19 SC 167074. That's the same disposition date of October the 28th, 2019. 1 year of confinement and 4 years of probation. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, is Ms. Craig on probation at this time? Are there cases that we need to be working through on that side?
I should be off.
Ms. Tucson, are you there? All right, we will come back to you. Ms. Nelson, maybe you can reach out to Ms. Tucson. Mr. Bastian, I would like to hear from you what you want to share, and then I'm going to have some questions for Ms. Craig as well.
Yes, Your Honor. We do want to begin by giving our condolences to the family, Your Honor, and none of us want to be in this position where we have to testify as to our loved ones and in the past, especially. As far as Ms. Craig, these are certainly a set of unique facts in my entire legal career, Your Honor. And to my client's benefit, I must say that she does also agree with the family that he was a very nice man. That's part of, and but she had nothing to do with him, the passing. She does think that maybe, and that's what the plea is about, that maybe she could have used better judgment as far as reporting or something like that. She just thought that it was it. And the statute entails other things that even if you hinder within the discovery, so that's why we're here. But as far as her, either if it's in their minds that she participated in him taking any drugs or anything like that, or being part of it, that was not the case. And she did not seem to witness, at least at the time that she was with him, that he was engaged. He was definitely ill. That's the one thing that she knows. But as far as she's concerned, she doesn't have much of a history. She believes that she's off probation, but we'll hear from Ms. Toussaint what it is. She's been incarcerated for quite a while. She's nearing the 2 years now. She has a family as well. She has a daughter that's 16 years old. She was 10 years old. I'm sorry. She does have a permanent place to stay in the Atlanta area, 6170 Hillendale Drive in Antonia, Georgia. If after this, she's just going to try to be a good citizen. She has learned a lot from this. Not only even being a good Samaritan probably pays a lot. We do see the recommendation, but we ask that the court grant her for time served, although 2 years. She's nearing the 2 years. She's not there already, and that the rest be served on probation. If it was for us, we would ask for 3 years of probation rather than the 5, given that she spent so much time in jail, and she is going to cooperate. She'll tell whatever she has to say to try to further the investigation. She understands that that's a vital part of it. So we ask that the probation being 3 years. If your honor is inclined to force for her to serve the entire 2 years, we'd rather that add some probation time rather than her to have stayed there. She's been a good citizen at the jail since the arrest. She has not seen the outside at all. And that's what I have to say.
Okay, thank you. Ms. Toussaint, are you able to join us now?
Good morning.
Hey, how are you?
I'm good. How about you?
Okay, is Ms. Craig on active probation?
She is on active first offender probation. Would you like the docket numbers?
Please.
18 SC 163438 and 19 SC 167074.
How much time remains?
On the first one, 1 year, 2 months, and 30 days. And on the second one, 1 year, 5 months, and 2 days.
Thank you. All right. Ms. Craig, I'm going to ask you a couple questions and then you are free to add anything you want. You're under oath right now. It is important that you either say, I'm not going to answer that question, which would be inconsistent with your commitment to providing truthful testimony in connection with the investigation into the death of Mr. Woodall, or you answer truthfully, because I am confident that the district attorney's office and maybe law enforcement will be following up with you, with your lawyer involved as he deems appropriate, to learn more about what happened to Mr. Woodall. So on the night of August 4th, or whenever you first encountered Mr. Woodall, was he alive when you first met him?
Yes.
Okay. And was he driving the RAV4 or was someone else?
No, he was in the driver's seat. And you could smell the alcohol all on him. He was in the, you know how you drink, he talking, he's in a good move and whatever.
Why were you interacting with Mr.
I
Woodall?
seen him in the parking lot.
Parking lot of?
Dairy Queen.
Okay, the parking lot where he was found.
Yes. He was
Okay.
in the Dairy Queen parking lot, was having a conversation.
You and he were having a
Yes.
conversation?
Yes, he was in a good mood. You could,
Okay.
you could smell
So
it.
you and Mr. Woodall are having a conversation.
Yes.
And is Mr. Arnold with you while you and Mr.
Not there at the moment, no.
Okay, and who is the third individual that we've heard about?
We dropped somebody off, but I didn't really know who that person was. I really don't know who that person was.
So who was driving Mr. Woodall's car when you
I
dropped?
was driving.
You drove his car?
Yes, because when we was talking in the parking lot, he was like, "Hey, how you doing?" We was just having a good conversation, and I asked him for a ride down by Publix. And as he was about to bag out, I said, "Are you okay? You sure you don't want me to drive?" He put the car in park, got out the driver's seat, and let me get in the passenger seat. About time I got to cook out, he's like this. And haven't heard a word from him since. And that's really the end of the story.
So you were driving?
Yes, I was.
Okay. Did Mr.
Arnold, yes.
Correct. Did he ever drive?
Yes, he did. I did let him drive. I had permission from the guy that passed that I could get in the driver's seat and drive to Publix, but I didn't even make it to Cookout all the way. And he's like this. He was still breathing. I even took him back to where I met him at, came back a couple hours later and checked on him. He was still breathing, drooling, snoring. So me and my buddy, well, Arnold, we drove a couple places, made a couple stops, and we brought him back to Dairy Queen. And that was the end of it. He's a great guy. He was an amazing person. He had good conversation.
So I need you to stop. How many other people ended up being
One.
this person whose name you don't know?
Yeah.
Okay.
And he got in the backseat.
Okay.
Yes, Mr. Arnold, well, the person that passed, he got out his driving seat willingly and got into the passenger seat.
I've heard you say that.
Yes.
Okay. Is there anything you want to add, Ms. Craig?
I'm sorry that if I would have known anything that was even possibly wrong with him, I would have took him to the hospital. But all I smelled was alcohol on him. He didn't ask about no drugs. I didn't hear about no drugs. I didn't even see him do anything. And if I would have known that it was something wrong with him, that he needed to be rushed to the hospital, we sat in the truck and talked for almost 15 minutes before I pulled off.
When you say the truck, you mean
Well, the Jeep was silver.
whatever it was.
Whatever it was, silver.
Okay.
Yes.
All right. Ms. Craig, I find that there is a factual basis for both your guilty pleas, the shoplifting as well as the concealing the death of another plea. I also find that your pleas are knowing and voluntary. Voluntary means no one's forced you to enter these pleas. You've decided upon advice of counsel and maybe others to move forward with a plea. And a knowing plea simply means that you've understood all the things we've been talking about and concern in relation to the rights that you're waiving, et cetera. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, which means that while you are on probation, which you will be for a while in this case, if you have a minor violation, you and probation will resolve that. If it is more significant, if you get arrested again, that comes back to me.
Yes, sir.
Mr. Jordan, what is the status? And I ask this more for the Woodalls than for me, but I am interested as well, of Mr. Arnold's case. Is that something that's going to be a trial, it's working towards resolution, or you're going to be talking with Ms. Craig?
Your Honor, we'll be speaking with Ms. Craig, and I'll also, pending those conversations, I'll reach out. I believe Ms. Feely is representing Mr. Arnold on the other case. So how those conversations pan out, I'll be able to convey an offer to Ms. Feely ahead of the June 8th final plea that Mr. Arnold has.
Okay. Ms. Craig, do you authorize my staff to sign the two indictments indicating your guilty pleas?
Yes.
Mr. Bastian, can we sign for you?
Yes.
And Mr. Jordan?
Yes, Your Honor.
Mr.
My apologies, Your Honor. I do see a note where that previous case that probation, Ms. Tucson mentioned, it looks like the first offender may have been revoked on that already, and she's been resentenced according to a note that I have from March 4th of 2022.
Let me look. That is correct. Judge Ellerby did that in both cases in March of this year. So we don't need to deal with that. Thank you for flagging that. So Ms. Craig, I agree with many of the things that I have heard through Ms. Curtis about the irreplaceable losses that the Woodall family has experienced. This is an odd set of facts. You've told me under oath that your interactions with Mr. Woodall were pleasant. He may not have been in a real coherent state of mind at the time, but it doesn't sound like the state has any evidence at this point that you engaged in any foul play. You might have engaged in some questionable decision-making in what you did with Mr. Woodall and his car, et cetera. But you seem very sincere when you insist that your interactions with Mr. Woodall were pleasant enough, and then he had gone to sleep, slipped into unconsciousness and whatnot. And then one wonders why you didn't take a different course of action then, but that's not what the law requires. You are dealing with the repercussions of your inaction, but you'll only be doing that for a little while longer. And obviously the Woodall family will for years to come. It's a very serious situation. I trust you will continue to work with the state as they try to get to the bottom of what happened in August of 2021. I'm going to sentence you in case 22 SC 181861, which is the shoplifting case, to 2 years to serve. You'll get credit for the time that you've been in. And according to the system I looked at, you've been in for about 622 days. You'll get credit for that time and you'll serve out the 2 years. That will close out the shoplifting case. In 23 SC 185695, the state is proceeding only on counts 1 and 2. Your sentence on count 1 will be 2 years to serve. Your sentence on count 2 will be 5 years. That will run consecutive to count 1. That will be probated. Special condition of probation number 1 is that you provide truthful testimony at any time you are requested to do so in connection with the state's ongoing investigation into the death of John J. Woodall. That means you do it while you're in custody. It means you do that while you're on probation until some resolution is reached, if a resolution is reached in connection with that. And a natural offshoot of that would be Mr. Arnold's case. So if Mr. Arnold ends up going to trial, you'd be required to testify. You couldn't say, no, thank you, I take the fifth, anything like that. You also are to have no contact with Mr. Arnold while you are under sentence. Whether you serve the full 5 years of probation or not really depends on how you do on probation. Probation is very interested in moving people to unsupervised probation if they're doing well, and then maybe even suspending that probation if they're doing really well. But you will determine that much more than I will. If I am brought a petition a few years into probation saying Ms. Craig is doing all the right things, I will consider it. But I think a reasonable sentence, given what you shared with me this morning and what I understand a bit more about what happened on August 4th, 2021, is the sentence that has been negotiated and that I have imposed. It does not bring closure to the Woodall family, but it closes a chapter. They have heard a little bit more today from you about what you perceive to be happening that evening. They will learn more through Mr. Jordan and the Atlanta Police Department as more investigation is done, and we'll see what happens with Mr. Arnold's case. But I don't mean to pretend that the Woodall family should leave here today saying everything is okay. It's not. The loss is not undone, but one piece of the puzzle is in place, And it sounds like to me that will put a few more pieces of the puzzle in place as well. It also sounds like the picture that develops as the puzzle is put together may not be a particularly happy one, but that's not what I heard you ask for. You wanted to know, what does the answer look like? And answers aren't always happy, and they don't always bring people the sense of, oh, now I get it. It may leave more questions, but different questions about what Mr. Woodall may have been working through at that time as well. But more to come with that. You, Woodall family, are welcome at any and all proceedings. At a minimum, we will work through Mr. Arnold's case, whether it's a plea or a trial. The district attorney's office will keep you apprised as to when those dates are. We don't do events by surprise. You're welcome to be here in person. If that is difficult, either emotionally or logistically, you can patch in just as Mr. Woodall's mother has. There's always a Zoom link that can be provided to family members and folks who are close to Mr. Woodall. So I appreciate your appearance today, and Ms. Curtis, you sharing sort of the global family perspective as to what the events of August 4th, 2021 have wrought. I have kids the age of the Woodall kids, and I don't like thinking about what it would be like for them if mom wasn't around. They'd probably be fine if dad wasn't around, but if mom wasn't around, that's not easy. So I'm trying to appreciate what you're going through. It's been a long time to get even some of these partial answers. So we'll see where it goes. Ms. Craig, I trust you are learning from your 622 days, and there'll be more of them. And when the dust finally settles on you and you are able to get out of jail, I trust you will make a different set of decisions. If you don't, and we are together again because there's a new arrest for this or that, you should know, even though you may have the great Mr. Bastian by your side, the revocation won't go easily for you. So either you are figuring out a different way to move through life, or you're going to keep getting yourself into situations where you're grabbing sunglasses and running, or I don't even know how to describe the decisions you made in August of 2021, but they need to be different going forward, or you're just going to be repeating this cycle, and your stints in jail will get longer, not shorter. So you are more in control of that destiny than some of the other folks in here are of what's going on. Mr. Jordan, anything else in connection with Ms. Craig's case?
Nothing additional from the state, Your Honor.
All right. Thank you for your work on the case. Mr. Bastian, thank you for getting involved with this case and navigating to Ms. Craig to where she got.
No, I'm young.
All right. All right. We have Mr. Hello, Mr. Adams. I'm all right. What are you here for?
When Darius Rose, he's replaced him on the walk-in calendar.
Is he here?
He moved the car because he's been at since 9.
Okay. Well, I trust he's in the bathroom. He can get out of the bathroom. He missed court when?
It was on the, I believe it was on the 11th. Because Grandma Devin mailbox got knocked down, so she had to go and pick up.
What day was it?
Well, better yet, what case number?
I don't know, Mr. Adams.
Well, I'll get it from Ms. Nelson and we'll figure it out. How long do we think Mr. Waller will take? I got a few minutes before I need to break for our 1 o'clock.
No longer than 5 to 10 minutes, Your Honor.
Not as long as Ms. Craig's situation.
Yes, Your Honor. Very, very brief, as they will just give their reasons for their recommendation.
Okay. Ms. Wood, are you ready to go with Waller?
Ready, Judge.
Okay. Let's. Can we bring Mr. Waller out when you're ready? So Mr. Adams, it looks like you have filed an entry of appearance, which has addressed Mr. Rhodes' primary issue, which was getting a lawyer.
Yes.
Okay, all right. That's all right. So Mr. Rhodes, you have retained Mr. Adams in your case. All right, Mr. Adams, are you going to waive arraignment for Mr. Rhodes?
We will, yeah.
All right, if you would fill out, there's a waiver of arraignment form. One of those there is the waiver of arraignment form. If you and Mr. Rhodes would fill that out, and let me make sure. Mr. Rhodes, you still live at 886 Midway Street? Okay, so you'll get notice. Mr. Adams will be getting notice as well, and he's got your contact information, but he's going to fill out this form. Once he's done that, we'll be able to do a scheduling order and get your case moving along.
That indictment number is
It is 22 SC 185234.
I'll make sure to inform Mr. Hiles that Mr. Rhodes did appear, because I believe that's
It is.
belongs to the game.
It does. Thank you. We got Mr. Waller?
he said, well, we know.
We got one more okay.
Yeah, he's always
We also have position 1 on the plea and arraignment calendar, Bobby Bradley.
Oh, Mr. Bradley showed up.
So he was just released on April 26th. He's in the process of getting his job back, but Ms. Rockwell did call him and let him know about this court date, but it wasn't until he got here as soon as he could. He is on house arrest. So I got him to fill out a change of address form. I don't think I need to be helping with the arraignment, but I do know he intends to hire Ms. Rockwell.
Okay, but right now, Ms. Bray is listed as his lawyer.
So that was from when he was in jail, I believe, or maybe even long before that.
Right, but if the public defender represented him, they still until someone files an entry?
I very well could be in DeKalb once they're released from jail. That is like a
Got it.
point in the process, but I.
Are you Mr. Bradley?
Yes, sir.
Okay. Are you hiring Ms. Rockwell for this case? Okay. Well, I think for right now, then the public defender is going to represent you. Ms. Feely, I don't know if 2 is your number, but if you would, I don't know if you want to waive arraignment, how you want to work that. If you want to talk to Mr. Bradley about that, or if he should talk to Ms. Wood, or if you need to do intake. I'm not trying to rush you on this, but I'm hearing Mr. Bradley say, maybe Ms. Rockwell will get in the mix. And until she does, then it is your office's case.
Sure, I can go ahead and file an entry today and I'll speak with him and get basic information and get this change of address for him.
Excellent. I'll make sure there is no bench warrant. So we're going to get a change of address, a waiver, and we'll do a scheduling order. All right.
Judge McBurney.
Yes, Ms. Wood.
This one will be mine. I'll do the waiver. If Miss Feely could just talk to him and get the information, I'll just go ahead and file the waiver.
Excellent. Thank you. So, Mr. Bradley, you're going to want to give all your good contact information to Ms. Feely.
I don't understand how he does not have that amount of.
It's okay. We're going to get it all connected up.
Yes, sir.
And that's 88 Willingham's case, Your Honor, and I'm emailing her right now just to let her know that he did.
That he showed up. Thank you. Okay. Did you get that filled out, Mr. Adams? Okay, you can just give it to the deputy. He'll get it to me. And we'll get a scheduling order in place, and that'll be, you'll get discovery from Mr. Hiles. And then you and Mr. Rhodes can start talking about the case, and you can start talking with the prosecutor.
Okay, can we wait, can we withdraw the warrant?
Yep.
Okay, thank you.
You bet. Okay, let's get on the record, please, in State versus Waller. It's 14 SC 127830. That's an old case, but I have a warrant that I signed in February of this year that alleges that in January of this year, Mr. Waller committed a new offense, aggravated assault, simple assault, family violence, battery here in Fulton County, and it provides the booking number. So basically, Mr. Waller, what we're working through here is, should your probation be revoked because you got arrested for some new crimes while you were on probation? Ms. Wood, are you ready to go forward with Mr. Waller?
Yes, Judge.
Let me, thank you, get, so he can see you. There's that. And then let's add Mr. Waller. There's Mr. Waller. Okay. Ms. Tucson, how much time remains on Mr. Waller's sentence?
He's the one for revocation, right?
Yes, ma'am.
He has 11 years and 25 days remaining.
Wow. Okay. Yep, a lot of probation. Okay. Judge Downs. All right. So Ms. Wood, is Mr. Waller stipulating to the arrest for the new offenses? Is he contesting this? What's his plan for moving forward?
Judge, Mr. Waller wants to stipulate to the arrest only, and then we have a different recommendation as far as the revocation than the state.
Okay. So Mr. Waller, you are not admitting that you committed aggravated assault, family violence, battery, et cetera, but you are effectively admitting that in January of this year, you got arrested for those things. Those charges are still out there. I don't know if you've made bond on those, but you'll need to work through those new charges at the appropriate time. Mr. Jordan, what is the state's recommendation?
Your Honor, the state's recommendation is that Mr. Waller be revoked for 2 years for this particular offense. This was a very dangerous situation. The state did have Officer Kent, I don't want to mispronounce her first name, under subpoena ahead of today. She did respond to the incident location and meet with the victim, Miss Mayo, and that's Mayo. She said that her boyfriend had just assaulted her and grabbed her by the neck, and it also damaged her vehicle. Officer Kent was able to see surveillance footage that showed Mr. Waller at the Exxon gas station pump charging at Miss Mayo, grabbing her by her neck and slamming her to the ground. The footage revealed that there was a scuffle between Miss Mayo and Mr. Waller. The footage shows that when Miss Mayo's daughter, who was also present at the scene, exited the store and noticed the fight between the two, she intervened by striking Mr. Waller after he stood over her mother. Mr. Waller then pushed the daughter away and they exchanged punches. Then you can see, Your Honor, in the surveillance video, it's a chaotic situation. There is a part where Miss Mayo does drive her vehicle at Mr. Waller. He is able to get out of the way, but you can see him throwing objects, including bricks, at the car as the car is leaving the scene. Miss Mayo has come to the office multiple times and has tried to get the charges dropped for the incident, but we have confronted her with the fact that this did happen on surveillance footage. The only, and the state will be fair, that the only particular incident that is not clear from the footage is the actual strangulation that she alleged, when they are fighting and wrestling, they do go behind a gas pump at one point, and it is difficult to see them. I believe that's when Miss Mayo alleges that Mr. Waller was choking her and saying that she could barely breathe, and that Mr. Waller said to her that she was going to die that night. Your Honor, this is a very serious situation. They had to get helicopters involved. They were able to find Mr. Waller, but apparently he did flee from the scene initially. They used helicopters to find him. He was found not but a few yards from the incident location, but given the seriousness of this incident and the fact that Mr. Waller is already on probation for quite some time, the state would ask that Mr. Waller be revoked for 2 years.
Okay. Ms. Wood?
Thank you, Judge. I just want to point out the new case that is assigned to Judge Ingram, he's in no bond status on that one. So I want the court to be aware of that. He has been in custody since January the 28th of this year. So right at 116 days, we're asking the court to consider revoking 6 months of his probation and reinstating. It's my understanding this is his first violation of probation while out on this case. I believe he was released from custody from the initial sentence from Judge Downs in 2019. He's 32 years old. He's a lifelong Atlanta resident. His whole family lives here. His mother is actually in the courtroom in support of him. And if the court has any questions for her, she's eager to speak with the court as needed. The address that he could live at is 3244 North Fulton Avenue, apartment F6 in Hateville. He had gainful employment before the arrest at Nicola's restaurant. And previously, Judge, I believe this case was erroneously assigned to your drug court side. So I know he worked with Ms. Hankins for a while in this case as well. I believe alcohol was a factor on both sides. And we would just ask the court to revoke 6 months and reinstate.
What did you do at Nicole's restaurant? What was your job there?
I was dishwashing.
How long had you been there?
Like 2 months now.
All right. Anything you want to add? So, Mr. Jordan, what you've shared is that Ms. Mayo has told your office that nothing happened, or that she's not interested in pursuing the charges, not that that's not her decision.
Initially, she did say that nothing happened. I believe, Your Honor, and that she did not want to proceed forward with charges. I believe her exact statement was to the victim advocate was that the situation just got out of control. But she did admit to telling officers that Mr. Waller choked her. And we also did explain to her that this is, of course, on surveillance footage.
It sounds like the surveillance footage shows several actors involved. Ms. Mayo driving her car at Mr. Waller putting hands on people, Ms. Mayo's daughter putting hands on people. Okay. All right. Mr. Waller, I find that you have violated the terms and conditions of your probation by getting arrested for these charges. The exact impact of the charges and what really happened can be sorted out in front of Judge Ingram. You'll have a lawyer there to help you with that. You are in no bond status there, so you're going to need to figure out a good way to move forward in that courtroom. I'm concerned about how you and Ms. Mayo work through disagreements. I'm also concerned that you've already had a chance to say, I messed up and I've turned a corner with the sentence that you got in this armed robbery case where things got reduced to robbery and you got a relatively short jail term and a longer probation term. But I'm somewhat reassured by the fact that sounds like since 2019, there weren't too many hiccups while you were on probation. I am going to revoke 18 months of probation, so 1 year, 6 months. You'll get credit for the time that you've been in. This will also be something that Judge Ingram, I assume, will factor in as she's sorting out what ought to happen in that case. And your lawyer there will be factoring that in. I'm going to add a special condition of probation so that when you are out, because you'll be reinstated on probation, and that's that you submit to a drug and alcohol abuse evaluation. And if that results in any treatment recommended, you go to AA classes or something like that. Maybe that'll help you stay out of situations like whatever the heck happened at the gas station in January of this year. All right. Thank you, everyone. Yeah.
So you said I got to do 18 months.
Well, you'll get credit for the time you've been in. And when you get to Judge Ingram's courtroom for these new charges, that may be something that they want to weave in there as well. Okay.
And can I confirm that it was revoked 1 year, 6 months?
Yes, ma'am. Credit for time served.
Thank you.
You're welcome.
Your sentence is 18 months, starting with the date that you put in on this warrant. So what's your first name? Okay, hold on, let me get to this page. And then
All right. I think that gets us through this morning's calendars. We're going to probably start closer to 1:15 this afternoon because we ended a little past 11:30, but Ms. Waller was here and I understand why the Craig plea took as long as it did. So I will get back as close to 1:15 as I can. And we'll work through the final plea calendar. So folks, enjoy your lunch break. I'll leave this Zoom session up and we'll reconvene then.
Thank you.
We is doing the time at rush. The whole thing burn. Yeah.
All right. So we'll start more like 1:15. I don't know how many of these guys are in custody. There are only 6 on the calendar. Okay.
Boyd and Campbell.
Okay. Campbell's lawyer is supposedly in trial, so I don't know if we'll be able to move that forward. Hightower, I think, bonded out. Elder's not going to show up. Walker should walk in. Thomas was the Omega who shot that guy that we had the immunity hearing, but I granted his motion, so he's done. The dude choked 2 people out and was running towards him. Man, I wouldn't.
He was too aggressive though, man.
Way too
aggressive for. And then he knew what karate, jiu-jitsu.
Jiu-jitsu. He was a amateur mixed martial arts fighter.
Yeah,
like that.
I
I was not gonna let that guy come. Like he didn't. He's running.
Got to.
And Sean, one time and stay right there. There was none of these, and then he's standing over. So it was generational. That guy was older, he didn't need, everyone was drunk, he hadn't even gone.
Right,
So anyway, they'll appeal it, we'll see what happens.
like Mr. Hall yesterday, he got 8 times. That's crazy.
That will have a different outcome than that guy.
Mhm.
Yeah, that didn't go well. I hadn't seen it, that scene in a while. That was,
Like on camera too.
yeah. Yeah. All right, thanks guys. I'll see you soon.
I never seen something here. Murder cases, man.
I guess I come back. I guess I'll be back with you.
It was on lunch.
Yeah.
You brought lunch, we gotta go get it. I just started on that.
Man, I can't afford that shit, man. Man, my daughter in college too, man.
Yeah,
That
I see
shit
everything.
be killing me, dog.
Oh, I know.
You know, like,
I got a 1-year-old, so I gotta keep my pound drill. I'm about a pound for the middle.
That will kill you. That guy, man, that guy will milk.
Yeah. I've been trying to get a weight, they won't get a weight.
Yeah.
Oh.
Go back, I gotta get it on warrant cancellation form, right? What? Yeah. Man, she wanted to talk about
No, listen.
I said, you know,
Remember this.
yeah.
And she was like, no, she not understood. That shit lie. You probably like, she not understood.
She be all right. I'm going to come back. Where's that go? You got time? Man. You also pay? Let me see now. Yeah. I'm glad to, I'm not. Listen, wait right here. This lady. This lady. Is. I just. This lady went right around with this dude in the car. And dude at OD of heroin. And they just ran around the car with him in the car. He did. So they take dude, I still lost money, get lost money, stuff like that. And then they leave his ass at 10 weeks off around, leave his ass. Man, this shit is crazy, man. I'm sitting here like, what the fuck? And I'm like, look like, nah, because you see, it's crazy. I'm like, I can't believe it. Huh? Man. I'm gonna look at them. I bet. That's a damn issue, man. That's what I'm talking about. And I ain't do that. But then, the dude right here, he gets in a fight with his girlfriend. They got this shit, all this shit on different. And I'm looking at him like, what in the hell? They got all this stuff on that account. And I'm like looking at him like, this motherfucker got them so quick girlfriend, they got a fight. You know, ran ass over the car. He got that front breach, rocked that damn car, was tight into the shit. I was like, what's that? This motherfucker, they had called a helicopter. That shit. They do the all the time. And I'm like, the more and more I look at myself, I said, man, this thing got me. This is crazy, guys. It's crazy, guys. And I'm just like, listen, I'm saying, man. Hey, this is great. So they get out of open probation, you get 18 months. We like, we learn shit. Get up to it. This and that. Took the damn money and all this shit, all this and nothing, and fucking money and shit. Here. Like that shit, boom. This is all open, this is about the owner. This is all open, this is about the owner. This is something like that, right? Oh. He outside, like my car. What are you doing? And he stayed like a idiot. Nice, what happened to me? I even now super. Well, Every day I. So. I do not know those brain just in the day. We're gonna go to driver. What? Are you going to the house? Oh, you go now. No, I'm gonna go. I'm gonna pray, Saturday night. You done? Yeah, that's right. I told that shit, when I said that shit. Damn, I'm mad as hell. You were a school because your family did that. Yeah, I ain't like, I ain't gonna. That's a good job, done. That's all. I would crazy. That's right. Go ahead and put the cross out. Okay. I know that one stop, so. Right. That's all right. We boarded up here? No, it wasn't like. So 115? Yes. No, trial right now. No. Okay. Cool. I ain't breaking the high dose up. Oh, he's working with the cat, same. He said what? He was the main. That's how. Should have told her that things, bring that to the drop. Yeah, of course. Thank you. I'm sorry. I ain't eating that. Everybody know. Start on now. Quite like that. Oh, you talking about, man, I did dread. What did you do? Both person gas and facing to eye, assuming you know, start eating. Start fixing like that, you know, we can pack up for eye. The rest of the trash. No, everything's fine. Instead of four person down the face of these. We had a good time for that. I'm still gonna have a wife. I'm still gonna have a wife. We're calling the council. Oh. He said, what now? They weren't even there. So I was better know she wasn't even there. Sean wasn't even there. Oh, everybody knew that. What? Oh, reading that phone? can't do that. I like this stuff. I got put Korean people. Just got there, he just well, man. What doing? So everybody, yeah. So are you trying to say that they hate on YouTube? Or just the fact that that incident may happen like that? I said, no, I said, no, this. That's what I said. He's not for
So we go with the violence. I used to so it's usually LCOS, PIP, something like that. I'm not all in. Oh, yeah? I got it over. It is good at the I know, I'm not seeing all that. Oh, that is more. I knew that. I don't do more. Going up, life numbers is no reason. I'm saying, so. Yes. What I'm saying about, yeah, so, VID. Yeah, I don't know. What's it now? I'll let y'all know. What time is it? Yeah, where? Yeah, you know, yeah. I didn't plan out to tell you. Lord. I was gonna get my meal, I wanted. Yeah. Okay, so we I'm back at that airport. And my friend, cause he got you were like cross street or you were behind? Behind school, so. Who was the road? I make a left and the light. And first round to there, like, why you say? Yeah. Oh, okay. I'm stay out, terrible, man. Whatever will go wrong, terrible. I'm sorry, Boulevard. No, Boulevard. Oh, yeah, it's already different, man. Like 15 minutes on every morning, If I don't expect that 15 minutes, I get another 15 minutes, terrible. Yeah, man, in license. Don't tell me that, cause I go, me, I'll be on the spot. No, I go down, I put myself in the ball, take out, take it right 4 o'clock. And it was all the way, 42 weeks and more than that, to the right. And I moved around. I didn't know you do that. Yeah. You know, yeah. That's it, go all the way down to the floor? Yeah. Yeah, you know what, but it's for how it going to with in Atlanta is more, but it's more, sports. Yeah, more, I turned left on Common Road, I cut the way, go down for a road. I take on the road all the way down, so I got down. Oh, yeah. Now, all here that they're training this man, straight up. That's it, man. Yeah, I don't know, man. I can see it. That's that's what we have. Wait, I'm such a way to say as soon as I called it, I should call me. Sure. What? Hey, I told her how, so I was at that time, yeah. Oh, here. So you got everybody up? That's up. I gotta go get it. Oh, all right. We gonna put my seat. You missed your home. All right. So 115. Yeah, he's trying to get
I.
Appreciate it. Still like
This is on break.
You get it as a norm. See, I mean, I really didn't like it. What you get.
What are you? Good. Don't breathe, 115. How do you get? that shit out, phone on top of them.
How you doing? What case? Yes. Oh, nice to meet you. Sure, yes. I submitted the application to get a new answer. For some reason, they haven't given me an answer yet, but that was just gonna be my announcement for today. It's just waiting on the words in the health version if they accept it.
Okay, thank you.
I'm good. Gonna stay on this side? Oh. You go inside, you go. I'll get out of there.
Election one. Huh? I said election one.
How you doing? Since you already got it on, I'll just stay over there.
Hello?
I don't break, still say don't break to 115, but that's fine.
We can hear you in the courtroom, mute your phone.
Hello?
You might have to get introduced to the judge. How do you get introduced to you? What's your like full preferred name? So Mary. And then say it again, Rafael. But do not specify. I'll introduce you. All right. But he may ask you some questions.
Hello?
Pork on the water, Ready, City?
Get our last calendar du jour. Welcome back, everyone. We're here for the final plea calendar. I think Mr. Kennedy is not available, but let me double check. He was going into trial this week. Mr. Jordan, do you have an update on Mr. Campbell?
Your Honor, I saw that same conflict that was filed by Mr. Kennedy, but we do have a final offer that was conveyed to Mr. Kennedy. Was not reported to me if he accepted that offer or not.
Okay. Can we bring Mr. Campbell to the door? I'll just let him know that his lawyer was in trial and that we'll reset this. Had you and Mr. Kennedy been having productive conversations, or
Your Honor,
it wasn't flowing like that?
I don't believe it was flowing like that, but I do believe that this may most likely result in a non-negotiated plea.
Okay. Hey, Mr. Campbell, how are you? Good. Mr. Kennedy, your lawyer is in trial this week. I didn't know when we set our calendar what his schedule was, but he was called out to trial. I don't remember what jurisdiction. It's not Fulton County. So today was your final plea date. We're going to preserve your final plea rights and get Mr. Kennedy in here as soon as we can and get you in here to talk about, is it a plea or is it a trial? But we need him to make that happen. So I didn't want you to think we just dragged you down here for nothing. We didn't have his conflict information when we set this calendar. So we're going to work with his schedule to figure out how soon he can be freed up. We'll get the prosecutor in here and figure out what the plan is. Okay. All right. See you soon. Ms. Hightower is next. There's Ms. Hightower. Hey, how are you?
My understanding that we have applied for her to re-enter pretrial diversion and just wait for response.
We're going to try that again, huh?
Yes, Your Honor. We referred Ms. Hightower to the adult diversion program. I submitted the application last week. We did have a slight delay because we had been trying to reach out to the victim and had not been able to reach her. So we went ahead and referred Ms. Hightower back to the adult diversion program. Still haven't received an answer. I reached out to Deputy Toole and Deputy Henry today, but have not received an answer yet on if Ms. Hightower will be allowed to go back into adult diversion. Or my understanding, Your Honor, is that she was in a pretrial intervention program, but it was not adult diversion.
Right. Your office's program didn't exist at the time. So this is a new opportunity for Ms. Hightower. I don't know if the fact that a similar program didn't work out well will be an obstacle. But I'm confused as to what you think is going to happen now. This is the final plea deadline. Pretrial diversion is going to move at its own pace in your office. Is there an offer other than pretrial diversion that you're keeping open, or how are we going to leave things for Ms. Hightower? Because her next stop here will be a trial calendar unless she's accepted into pretrial diversion and successfully completes it.
Your Honor, I had been discussing this case with Attorney Arca previously. I have not extended an offer to him yet, but I can make sure that he gets one before the close of business, given that pretrial or adult diversion has not yet given us an answer. And I do understand we're on the eve of a trial calendar, or the next step would be a trial calendar for Ms. Hightower.
So this is a colleague of Mr. Arca's. I guess you two could talk, but what I'd like to have happen is before Ms. Hightower leaves, she knows that it sounds like the primary aim is to get into pretrial diversion and complete it. But if Ms. Hightower is not admitted because there was an unsuccessful attempt before, then this is the other situation. And you can let me know whether that offer is being kept open or not, but I'll want to get that on the record before folks leave today. Okay. So let me get through the rest of the calendar, which should go pretty quickly, and then then we'll circle back after you've had a chance to talk. Okay.
Thank you, Judge.
All right. Colby Elder, I see Mr. Elder on the screen there. Not quite sure, Mr. Elder, why you are there and not here. I'll put you on the spotlight so I can see you better. Where are you right now, Mr. Elder?
I'm at home.
Okay, but is that in Georgia or Texas or where?
It's in Georgia. It's in Atlanta.
Okay. Any reason you're not in court?
No, gave me the Zoom link to go to do it this way.
Okay. Mr. Rosenblum was on this morning as well. And he's here again. So I'm gonna add him. He shared with me this morning that you were supposed to show up in his office. I think it was yesterday. He'll clear it up to make things right financially. You didn't do that. So you tell me, Mr. Elder, what you think is happening in terms of representation.
Well, I had an emergency yesterday and I had to use some of my money to bond my girlfriend's car out of jail.
How does a car get in jail?
Well, she got it impounded.
Okay. So you've decided to do that instead. Mr. Rosenblum is saying he doesn't represent you. Do you qualify for appointed counsel or what's your situation?
Well, I was planning to get by there today. I was planning to get there today before 1 p.m., but I didn't make it.
Okay. So you're 0 for 2. You were supposed to be there yesterday. You were going to be there today. I don't really want to keep dragging Mr. Rosenblum virtually or in person into my courtroom. You've got this burglary case. This is final plea. We're going to keep moving it forward. What do you want to, you'll have time between now and trial, but it doesn't sound like we're going to do anything on this final plea date. So I'm going to move this to trial. Is your goal to retain Mr. Rosenblum or some other attorney between now and trial?
I'm planning to.
Okay.
Because I'm not guilty, so.
All right, well, I don't want to get into the facts of the case or the lack of evidence or whatnot. There's this indictment, and I'm just trying to move it along so it's not hanging over your head or crowding out anyone else's docket. What I'm going to do is move your case to a trial calendar. And I guess between now and then, you either need to get things right financially with Mr. Rosenblum and his firm or with someone else. But you'll need to be here, not virtually, but in person for the trial calendar call. And either you're representing yourself or you will have hired an attorney. Okay?
Okay.
Your Honor, just so I'm clear, does that, so we are off the case unless he rehires us?
Let me look at the docket here. So I see your motion to withdraw, and I will, let me see. You have an order attached. So I will sign that order today. That allows you, Mr. Rosenblum, to withdraw. You can always file an entry of appearance in the future if Mr. Elder has made that worth your while. Otherwise, we'll be moving forward with Mr. Elder as his own counsel. And Mr. Elder, you're free to hire any attorney you want. If you cannot afford an attorney, then you're going to need to get in touch with my staff so we can see if you qualify for appointed counsel. I don't want to delay your trial because you show up for the trial calendar call and say, well, I don't have a lawyer yet. I'm thinking about getting one. I'm making real clear to you right now that when you come to court for your trial, you either have a lawyer with you because you've hired one or you've let me know I should appoint one, or you show up ready to represent yourself. Okay?
Okay.
Any questions about any of that?
No.
All right. Ms. Nelson, oh, it may be in Odyssey. You're going to be on the August trial calendar, Mr. Elder, as you are planning things out in terms of hiring an attorney or making yourself available. You'll need to be available in the middle of August to be here for your trial. Okay?
Okay.
Just as a further scheduling complication, possibly this would represent the co-defendant who has his case is closed, but we would need some extra notice to make sure to get the conference.
Right, because you wouldn't be representing Mr. Elder. It would be a conflict lawyer. Got it. Okay.
We can make it happen. We just need
election notice.
Understood. Okay. All right, Mr. Rosenblum, I'll sign that withdrawal order today.
Thanks, Judge.
All right. You're free to go, Mr. Elder.
All right, thank you.
Ms. Walker. I saw Ms. Taylor on, there's Ms. Taylor.
Yes, good afternoon, Judge. Ms. Walker should be on the Zoom, Judge. When I got the email, I didn't know that she had to appear in person.
She doesn't necessarily. Let's see what happens. I'm adding, there's Ms. Walker and there's Ms. Taylor. So your case, Mr. Shapiro?
It is, Judge.
All right. So Ms. Taylor, this is the final plea calendar. This is the last day for Ms. Walker to resolve her case by way of a plea. If she wants that ability to withdraw her plea, if the sentence that I impose is more than you ask for. Otherwise, we can keep moving it towards trial and Ms. Walker can always enter a plea some other day. She just wouldn't be able to back out of that plea if she didn't like her sentence.
Judge, I am in communication with Mr. Shapiro about this case. There are, he and I are kind of at a midway point. I brought out some points to him yesterday that I would like to further discuss. I believe we can resolve this case, Judge, without a trial, I believe. What I was going to ask the court respectfully was I know you probably would move it on to a trial calendar, but reserving final plea issue, and certainly we would approach the court before any trial calendar regarding a final plea. Am I stating that right, Mr. Shapiro?
Well, I'm going to ask Mr. Shapiro what he has to say in just a moment, but I hear what you're saying, Ms. Taylor. I am looking to see, so you've been on this case for a while. Mr. Shapiro, I don't see that there's been, the last discovery certificate was from 4 months ago. There was a little more provided.
And there's a co-defendant in the case. There is a co-defendant in this case that's not on the calendar.
Okay. I think that's probably because he just got representation.
That's one of Mr. Johnson's cases. And so Mr. Brown, I think, has just entered an appearance on that one.
Yeah, the GPDC has been doing a good job lately of lining up replacements for those situations. And so Mr. Brown is on, but that's not Ms. Walker. So do you foresee more discovery, or you've provided what you're going to provide?
No additional discovery, Judge. I'm sorry, Ms. Taylor, go ahead.
No, hold on, Ms. Taylor. I'm talking with Mr. Shapiro right now. Is this a case where you think both defendants could be tried together? Would they need to be severed?
It is a case where both of the defendants would be tried together. However, as Ms. Taylor stated, we're in continuing negotiations regarding Ms. Walker's case. Any resolution would likely involve a proffer against the co-defendant. And so for that reason, I communicated with Ms. Taylor yesterday. We're not going to object. We have no issue with Ms. Walker reserving her final plea rights if the court were so inclined as we continue those negotiations.
Okay. And what is your understanding of Ms. Walker's connection to Mr. Cody? Do they share a kid, or what? So is that not the name of the co-defendant?
No, it is Mr. Cody. Mr. Cody is Ms. Walker's former boyfriend, was living, not sure if he was actually residing with her, but in and around the children, in the apartment at the time that the allegations in this case arose. And so that is her connection.
But they're shared kids. It was a shared household. Correct. Potentially. Mm-hmm. Okay. All right. So Ms. Taylor, if Mr. Shapiro is not objecting, then I will move Ms. Walker's case to a trial calendar. I'll preserve the final plea rights.
All right, thank you, Judge. That's all I have. That maybe be excused.
Ms. Walker, do you have any questions? I'll take that as a no.
No, sir. I don't know if y'all can hear me.
Okay, yeah, we can hear you now. All right.
Okay,
You two are free to go.
okay, thank you.
You're welcome.
Thank you, Judge. Y'all
You're
have to get.
welcome.
All right.
Judge.
So hold on one second. I'm just looking up Mr. Cody's situation. So that's on for final plea in about a month. Hopefully, Mr. Brown is up to speed for you and Mr. Jordan. He's on a couple of these they're new to him. I'll give him a little elasticity with deadlines as he's trying to figure it out. This doesn't strike me as a case where he's got a real steep hill to climb.
No, Judge.
One count of cruelty to children. Mr. Cody's in jail though, so I'm hoping this is one that Mr. Brown will connect with you soon on. He filed his entry promptly. And it looks like he's filed some kind of placeholder motions, nothing that would require a hearing.
And I think we've already served discovery on Mr. Brown. I'll double check that and see if there's a certificate that's been entered, but I think we've already served.
Yeah, the only certificate of discovery that's that same date with the jail call, that would have gone to Eric Johnson. So you may have informally done that, your office. There's nothing in the docket that says he has received discovery.
We'll make sure it's filed, Judge. And I
Okay.
apologize, I should have covered this while Ms. Taylor was still on, but considering that case is also on for a final plea in a month, I'll continue to communicate with Ms. Taylor and see if we can get those both resolved.
Yeah, let's do that. Mr. Cody's been in for over almost a year. In about a week, it'll be a year. And I don't know anything about the case, but it may be that he's fast approaching a length of time in where he and Mr. Brown could work something out with you.
Understood, Judge.
I don't know. Okay. But for Ms. Walker, we'll further notice it to a trial calendar and we're preserving her final plea rights.
Thank you, Judge. That's my only case this afternoon. Can be excused.
Yes, sir.
Thank you.
All right. Position 5 has been dealt with. And finally, we have Ms. Boyd. And I'm trying to remember who is, well, you'll know who's on for Ms. Boyd.
Cabrera Diamore.
Oh, that's right.
And she
had reached out.
She got called into trial in front of Judge Warren in Douglas. We've extended the offer. The offer is life with the possibility of parole. And she indicated that she, in the email to the court and us, that she does
think it's going to work out.
Going to be a plea.
Okay. So it's just a question of when.
Yeah. And I had been in communication with her pretty regularly before she got called in, just pointing out the more important parts of the digital evidence. So she
so that she, rather than sifting through mountains, she could go straight to things that would help her be persuasive with her client.
Yes. And I think she was getting ready to go have that last push, then had to change her trajectory to a trial. So I think you or Ms. Nelson might have indicated that it'd be reset for one more final plea. But it's one of those things that it's going to be, we're not negotiating. That's the offer. It's
right. You've laid out what it's going to be. It makes sense given how Ms. Boyd has been underrepresented for a while to have the formality of a final plea, so that her lawyer standing by her side at long last can say, here are the options. And Ms. Boyd is intelligently saying no, thank you to it, or yes, I'm taking it, or whatever her decision is. So I think that makes sense. We'll work with Ms. Damore's schedule to figure out when we can make that happen. There's a question. Yes, ma'am.
Ms. Boyd, you family members, so we just, since it's been going on so long.
So long is right. Boy, oh boy.
We've been calling the lawyers and stuff and no return of house. So we just here today because she did let me know what courtroom and all that is.
Sure.
Just let her know we was here.
We will. And is Ms. Boyd here? So maybe she can come to the doorway. You guys can't talk with her. That's not the point of this, but she can know you're here. And we'll let her, hold on one second. We'll let her know that her lawyer couldn't make it, but to court today, but that she'll be seeing her soon. again, we'll work with Ms. Demore, but any sense, I mean, if we get this on a final plea calendar in a few weeks, is there more work you had to do with Ms. Demore, or you've, like you said, already said, here's what you should look at in discovery?
So, yeah, so I think I need to get a few more, point out a few more in particulars that she can actually take to Ms. Boyd. I'm not sure I don't think she's had the time to actually take the computer with the videos, the jail calls, and then the Instagram returns. And as we were speaking a week and a half ago, whenever this calendar was published, that was the next step.
Okay. All right. Then if you don't mind bringing Ms. Boyd to the door, please, Deputy Gordon.
I need my number for a project.
For whom? For Ms. Boyd?
Well, she got my number, just said.
She's not going to be the one calling you, but what we can do is get you her lawyer's number, because she has a new lawyer, and you could contact that person.
Thank you.
Sure. Hey, Ms. Boyd, how you doing? I needed to let you know why we brought you over today. Today was supposed to be the final plea calendar where you and your lawyer, and you have a new lawyer. Have you met Ms. Cabrera yet? Okay, well, Mr. Johnson, you've had many lawyers. You've had too many lawyers, but for a long time, it was Mr. Johnson. He got wrapped up in this YSL trial, and so we've had to get new lawyers onto his cases, and you have one. She is a hard worker. In fact, she's in trial right now in another jurisdiction. The prosecutor, Mr. Hiles, gentleman with the yellow tie, has been working with your lawyer. There's lots of discovery in your case, and he's been highlighting these are the things that the state would be relying on so that Ms. Demore can meet with you to say, here's some good evidence, here's some bad evidence, and have a discussion with you about her thoughts about the best way to move forward. Should we try to plead? Should we go to trial? Life without parole, different options. She, your lawyer, will come meet with you as soon as, one, she's done with her trial, and two, she's spoken a little bit more with Mr. Hiles so she can more effectively share with you the discovery. I don't know if any of your other lawyers ever sat down with you with the discovery, but that needs to happen before you can be in a position to say, ooh, we should take this to trial. They've got no evidence versus, and I'm making this up. There I am on video doing whatever I'm accused of doing. And that's less of a case to take to trial. But you and Ms. Demore need to have that meeting, and it's probably meetings. So we're going to make that happen, and I'm going to bring you back here so we can figure out what we're doing next. Okay. Any questions? Okay. Well, important for you to know these folks were here on your behalf. I'm going to give them your lawyer's contact information so they can reach out. Okay. All right. She didn't put anything there. Let's see. So I'm going to give you a phone number. You ready? It's 201-780-7873.
201-780-7873.
Copy that. First name is Euphemia. You can spell it however you want. And then the last name is hyphenated. It's Cabrera Demore. Does she go by Ms. Demore, Ms. Cabrera when you're interacting with her, Mr. Hiles?
Well, I've known her so long, I just refer to her by her first name, but it is a hype. She got married since I've known her. And it's,
yeah.
She goes Cabrera Demore.
Okay. All right. They're going to manage that. Great. All right. So Campbell, we will reset. We have to reset Boyd. Thomas was dismissed. Walker for the notice to trial. Elder further notice to trial, and that leaves Hightower.
Yes, Your Honor, and I can put the communicated offer on the record.
All right, well, let's make sure Ms. Rivers is with us. Ms. Rivers, you ready to take this down?
Yes, I am.
Great. So this is position 2 on our calendar. It's a 19 SC case, 19 SC 167523, State versus Hightower. Ms. Hightower is here in court with her lawyer. Can you say your name again for the record?
Yes, Caprisa Clowney.
Ms. Clowney is here, and Mr. Jordan represents the state. I think Ms. Hightower is hoping that she gets another crack at pretrial diversion. We don't have that answer yet. So if pretrial diversion does not work out, what is the state's recommendation going to be if Ms. Hightower were to enter a plea?
Your Honor, if Ms. Hightower were to enter a plea, the state would move to dismiss counts 1, 8, and 16, which are 3 of the 4 counts that Ms. Hightower has on the indictment, respectively. The state would extend an offer of 2 years probation on count 3 for deposit account fraud, for bad checks, $1,500 or more. The state would not be opposed to probation terminating early after 1 year if there are no violations. And I do believe Ms. Hightower is also first offender eligible.
Okay, which is why pretrial diversion makes lots of sense.
Yes, Your Honor.
Ms. Hightower, do you understand what the state's recommendation would be if you entered a plea?
Yes.
Mr. Jordan, is that a recommendation you're willing to keep open until we figure out if pretrial diversion is a go or not?
Yes, Your Honor. The state would be willing to keep this offer open.
Okay. I'll check in with you and Ms. Clowney. What is a week enough time? Just have pretrial diversion figure out what they're going to do?
Yes, Your Honor. As I told Ms. Clowney outside that I'm not sure why they haven't responded yet, but I'll make sure to walk over there and take the file directly over there in the coming days and get an answer.
Ms. Hightower, why did pretrial diversion not work last time?
I was communicating with Ms. Tracy from the program prior. I sent her my deposit to start my orientation, and she never did send me the link because it was gonna be like the program was gonna be through Zoom. And she never did, send me the link, and then the number that she had attached to it that I was communicating with her, it just kind of gave like a fax number would do, like if it's a fax machine number. And so I couldn't get back in contact with her anymore after that. I never did receive the link from her to do the orientation at the beginning of the class to go ahead and.
Did you ever reach out to your lawyer to say, hey, this isn't working out well? Could you reach out to the DA's office? Okay, my guess is no, because they might have helped you sort through it. So if you get into pretrial diversion this time, hopefully their phone numbers work better. Some of it will be in person. And if for whatever reason you're having trouble connecting with them, reach out to Ms. Clowney, Mr. Arca, Mr. Howard, that whole firm. You've paid them, and they can help you make the connection. But if you just become passive and say, if they don't want me, I don't want them, then it's not going to work out. All right. All right. So the way we'll leave this is that if I haven't heard from you all about Ms. Hightower's acceptance in a week, I'm going to bug you, Mr. Jordan. I'll copy Ms. Clowney to say what's going on. And if Ms. Hightower is not accepted, then we'll figure out a way, given what this recommendation would be. It can be via Zoom, but we'll need to get a lawyer for Ms. Hightower plugged into a plea hearing.
Yes.
Okay. All right. Anything else, Ms. Clowney, on behalf of Ms. Hightower? Yes, you may.
Thank you.
All right. Sure. No pleas on the final plea calendar. Yes, ma'am. Thank you. Is this where your wife works? Where does your
She works at the Granville Group in College Park.
Different, okay. Sometimes she was on, it's not, okay.
We're pretty close to Mr. Arca, so she might as well work.
That's why, because I know he was all buddy with you. That's right, okay.
Yeah.
I think that's it. Anything, Ms. Feely from the PD's office?
We do have a summer intern here joining us from NYU. This is
Hey, summer intern.
Miriam Raphael Smith.
And NYU Law School, University, College? Law School, what year are you?
I'll do two.
Okay, great. Why are you down here?
There were other NYU students who did it in the past and spoke very highly of it.
So Retta Eubanks was here last summer from NYU
Mhm.
and was assigned to Lacey and I in this courtroom, and told her it was a summer she couldn't miss. And so
Excellent.
not disappointed.
All right. Well, hopefully you get some good trials, hearings and whatnot throughout the summer. We'll see how that goes. How long are you here?
To the end of July.
Okay, something will happen. I think that's it. Thank you, everyone.
Thank you, Judge.
Thank you, Ms. Jackson and Ms. Tucson.
Thank you. Thank you, Judge.
Cancellation of the,
Oh,
how about this? It's been sitting here. Watch that shit.